All persons having business before the Honorable Associate Judges, now presiding of the District of Columbia Court of Appeals, draw near and give your attention. God save the United States and this honorable court. This honorable court is now in session. Please come to order.
Good morning. We have three cases on the calendar this morning. We're going to take them not in the usual order, but we're going to hear the second case first, followed by the third case, and then get to the first case on the list. So I will call the second case now, and I'm not absolutely sure I know how to pronounce the name, but I will try. Iandis versus Estate of Ellie Mae. Counsel, you may proceed.
Good morning, Your Honor. My name is Stan Dorer, and I represent appellant Anastase Iannidis. And I must confess that it is a hard name to pronounce. To make it easy on everyone, I'm going to call him Taz, which is his name that he goes by. I'd like to reserve 2 minutes for rebuttal.
Okay.
Over the course of many years, appellant Iannidis, also known as Taz, made a series of loans to his longtime close friend, the decedent, Ellie Mae Woodland, at her request. These loans totaled about $187,000. These loans were made in the form of direct payments on the decedent's behalf by Taz for many things. He directly paid her mortgage from her bank account on her condo in Arlington, Virginia. He directly made payments for unit owners associations, dues for that condo. He made payments for some other repairs for the condo, but he made all these payments at her request, and he made these payments based on an agreement they had whereby she would pay him back when she could, or at the latest, when she sold or refinanced the condo.
Can I interrupt and ask? I noticed in the transcript at the hearing, the one hearing that was held, your client, no, it wasn't your, is it client, sometimes referred to, what was it that you just said? I'm sorry.
That the loans were going to be paid back when she could,
right?
not later
Yeah.
than
So
when
there
she
were some
resold the car.
references that took away that initial part, like, we'll pay back as soon as she could or when she sold or refinanced. But at the hearing, I feel like your client mostly said when she refinanced, which, I'm not sure how much of a difference it makes, but it does require you to then get into whether that condition precedent makes any sense.
That's correct, Your Honor. He did say that. One of the strongest, I think the reason for that is that based on their knowledge of each other, it was relatively understood that she was not going to come into hundreds of thousands of dollars short of that. And one of the big reasons that I think that wouldn't be a condition precedent is the fact that when she in fact did come into some money, she signed all of it over to my client. And that's in our briefing, but when she received $11,307, which was the entirety of her proceeds from personal injury, she diligently paid it back to Mr. Iannidis, and he wrote a memo depositing that money and saying, repaid by Ellie Mae. And I think, Your Honor, that's very strong evidence that these were loans from the beginning, because that occurred many years ago. And that,
can I ask you,
of course.
Can I ask you, sorry, I don't know if I'm causing that interference or not, but on the question of whether it can be performed within a year, this is, something you just said made me think of this about, does it matter how realistic it is? I think you were saying, of course, she could pay him back within a year. There's nothing like legally getting in the way of that, or maybe she would sell the house, or maybe she would refinance. But, you know, what's your understanding of the legal question there? If, as your opponent says, it's really not realistic to think that was going to happen within a year, and your client certainly didn't expect that.
I think the case law that I've read makes it clear that the statute of frauds is a statute of frauds and that cannot be performed within a year. I think the statute should be read literally, and that the precedent that says if it's capable of performance within a year, then the statute of frauds doesn't cover it. And here it was capable of being performed at any time. In fact, early on, when the loans were really low, there was no preset amount. It was understood that his payments toward her mortgage were loans. But I think ideally at the beginning, my client would have preferred that she just pay it back and start paying herself. But it turned out that wasn't feasible. But there was nothing preventing her from selling the condo the next day. There was nothing preventing her from getting a job and starting to pay the condo herself and paying him back. I think that the precedent says that capable of performance within a year, and this was certainly capable. This was just a loan. It was certainly capable of.
So it's like theoretically capable. Oh, that is definitely me causing that interference, but theoretically capable as opposed to anyone thinks it's going to happen.
Well, I would stick with what the case law says, Your Honor. And the quote I see, pardon me. In Snyder versus Hillegeist, this court said, the contract on which appellant relies is one which would have been fully performed as soon as the union purchased a building or building site. Obviously, this could have occurred within a year. So I think if it's capable of performance within a year, it's outside the statute of frauds. And I think the case law bears that out with where it is applied as well. After the oral agreement, there were some memoranda signed by the decedent that provide corroboration that these were loans. Specifically, there are numerous bills, if you will, that the decedent would provide to my client and say, Fortaz will repay. And this was all in line with their agreement. Basically, she was providing him these bills that she needed paid, and he would pay them with the understanding that they would be repaid. And he knew, as long as she had this condo, that she was good for it, essentially. However, ultimately, on May 30th, 2019, Ms. Woodland died without a will. And she had not paid him back at that time, aside from the $11,307. Mr. Ioannidis, while she was even sick, had been trying to get repaid, and it just did not happen. So after she died, he brought a lawsuit in the DC Superior Court against Miss Martha Woodland, a personal representative.
Can I interrupt you on that as well?
Sure.
Sorry, but what was the reasoning for, the judge seemed to think something that I was thinking, why isn't this all being handled in probate? What was the point of the separate action?
Your Honor, I think that it was, looking back, I think it probably should have been brought first in the probate, but it was brought in the civil division. But as soon as it was realized that this should be potentially in probate, and within the time limit set forth in the statute, which is 6 months after the publication, we tried to bring it in probate. We brought a notice of claim very similar to the original action, referencing the initial action in the probate court. So it happened that there were sort of parallel proceedings. And to this day, the probate matter is still sitting there open. So I have not much experience in the probate court, but we filed the claim and essentially nothing happened. And because we had a scheduling order in the civil case, we pressed it there. If the judge had transferred it to probate or something, we would have been amenable to that, but we just wanted to get a resolution. But there was a notice of claim brought in the probate court referencing the lawsuit, referencing the facts. It's part of the record in this case, and it was just nothing ever happened with it.
What is the current status of the probate matter?
I checked yesterday, and by my telling, it's just sitting there open. There's no scheduling order. The case is listed as it's there. But at the hearing in this case, Your Honor, the judge made clear, if you go forward here, that's going to terminate everything. So we've treated this as, because the judge said that he was not going to let us relitigate it in probate court, that his decision here was going to bind. So that's why we're here. But as far as I know, and I checked as recently as 2 days ago on the online website, it was still open there. There are 4 primary reasons. Oh, the last fact is that after finding out about this litigation, the personal representative went to Arlington and did sort of a summary transfer of the property to herself and her brothers. And so we amended the complaint to bring additional claims of unjust enrichment against the brothers. Ultimately, a default was entered against one of the brothers one of the decedent's brothers who never appeared. And when we had a hearing on damages, my client appeared and testified as to the loans and all the facts I just described. And the court basically refused to order damages based on the statute of frauds, based on a conclusion that there was a presumption that these were gifts, and based on his conclusion that if there was a contract, there was a condition precedent that had not occurred. He invited the other side to refile summary judgment briefs, which they did. Ms. Woodland specifically filed a motion for summary judgment, and then we briefed that, and then the judge granted the summary judgment for the same reasons that he had in the oral. Now, there's 4 primary reasons that we believe the lower court made reversible error. First, the court erred by holding that the contract violated the statute of frauds. Second, the trial court erred by holding that there was a condition precedent that had not occurred. And third, the trial court erred by presuming that appellant's payments were gifts. Fourth, the trial court erred by dismissing all claims against all defendants without even considering the non-contract claims. Regarding the statute of frauds, the court did not apply the correct statute. The DC statute of frauds is codified in 283502, and it applies to actions upon a contract or sale of real estate of any interest in or concerning it, or upon an agreement that is not to be performed within 1 year from the date of making. This statute does not apply. This is not an action upon a contract for a sale of real estate. Mr. Ioannidis does not and never has sought an interest in the real property via this litigation. It was not understood that he became the owner of the property based on these loans. The property is only relevant insofar as he made payments so she could keep the property, and it was premised upon her agreement that she'd pay him back when she could, but at the latest, when she sold or refinanced the property, which she never did. But my client does not seek the property here. And as we alluded to earlier, this is also not a contract that could not be performed or was incapable of performance within 1 year. This loan could have been repaid easily early on, certainly within a year. And there was nothing stopping her from repaying at any time, as is evidenced by the fact that she did partially repay $11,307. The court applied a statute of frauds that it said there's no dispute that this is a contract for a loan over $500, therefore the statute of fraud applies. That's not the statute in DC. The court also ignored our argument that there's an exception to the statute of frauds where is that timer, does it include my rebuttal time?
No, it doesn't. We'll give you, why don't you take a few more minutes and then you'll still have rebuttal time.
Thank you, Your Honor. I appreciate that. Even if the statute of frauds does apply, which here it doesn't, there's an exception where there's substantial partial performance. Now, we put into the record, especially our brief, we argued that her repayment of the $11,307 in writing repaid TAS for mortgage loans not only evidences the loan, but also is substantial partial performance. The judge, in a hearing on summary judgment, just ignored that argument and said that neither side argues there's partial performance. So that was reversible error right there. Finally, the judge also made points both in his oral ruling and summary judgment that there's a presumption that these were gifts. There's no presumption there's no precedent that I can see that applies a presumption of gifts. In fact, it's just the opposite. When someone provides services for someone else, the presumption is that they expect payment. Here, the judge flipped the standard by saying that there was a presumption that it was a gift that we had not overcome. We had put forth a lot of evidence. My client testified directly these were not gifts. He did an affidavit that these were not gifts. My client has many writings that call them loans. We have a repayment. All these things were evidence that we put on the record, tending to show that these were not gifts, but the court ignored all that in favor of applying a presumption that we believe is unfounded in the law that they were gifts.
Can I ask you, I know that you still have the partial performance argument that gets you outside of the statute of frauds, but within the statute of frauds, you are making this argument that your client is not seeking an interest in the property. The statute itself is pretty broad. It says upon a contract or sale of real estate of any interest in or concerning it. Can you talk about, and also at the ex parte hearing, the court says, okay, so your contention is that Taz paid $147,000 toward this particular property. Is that what you're saying, Mr. Hosa, I think? And the lawyer responds, yes, Your Honor. So there's a lot of sense that this money, these loans were going toward property related issues. What is your response to that? And are there loans that he made, that are more generic or more unrelated to the property than the ones we are kind of focused on?
There are some, Your Honor. She also had a bankruptcy workout at some point that was happening, and she specifically asked Taz to make repayments for that. And some of the memorandums that we put forth are, in fact, bills for that, where she says, for Taz will repay, they're part of the same series of loans. Regarding, this does relate to a property in the generic sense that there's timing there, but I would just point to the precedent. Two cases we cite in our briefs, Kyle versus Wiley and Snyder versus Hillegeist, are both fairly on point. Both of them involve arrangements to co-broker property sales that sort of go bad. Basically, there are agreements that pay, and I apologize if I'm getting these confused, but my reading of them is sort of similar facts, but there are agreements where people say, we want to sell this brokerage, this real estate together. If you're able to get title to it, we will sell it and you'll get a commission. And then the person gets title to the real estate and then enters an agreement with someone else to sell the property. And then when the original partner sues saying, hey, you sold that property, that was supposed to be a co-brokerage agreement we had, the defense was, well, this was within the statute of frauds. And that's where the case law seems to imply that it can't be just about this has some relationship to a property. historically, the statute of frauds, in as far as I can tell how it's written in DC, it relates to a sale of property, because the title of property needs to be, in the records and clear. And I think that's why a sale of property, why the statute specifically contemplates agreements for a sale of property or looking for interest in the property. There's case law, there's lots of case law involving real property generically that does not fall within the statute of frauds, and we believe that that's where this case would lie as well.
So before you sit down, let me just ask you if I have this right. From your perspective, what should happen is that you should obtain a money judgment against the estate in whatever the amount is, $175,000 or so. And to the extent the estate has no other assets to pay that judgment, you would want an order, I guess, requiring the personal representatives to possibly return the property to the estate. There might be a question as to whether the personal representatives need to be changed, and an order requiring that the property be sold to satisfy your debt. Is that the way you see this going?
I would certainly agree as far as the money judgment against the estate. I do not think the court would issue an order ordering anybody to sell the property. I mean, the property's in Virginia, first of all. So we certainly would want a money judgment against the estate. And also, importantly here, we would want a money judgment against the current owners of the property. We allege individual claims against Martha Woodland, John McLaughlin, and the other owner for unjust enrichment, because essentially, the estate right now doesn't have any assets, but we would allege that they were unjustly enriched by sort of foreclosing the process instead of letting the process play out as it should have, by just saying, hey, let's transfer it to ourselves. So I think a money judgment is what we would
formalities, once they opened the estate, were the formalities of giving notice to creditors and so on and so forth fulfilled?
Your Honor, I know on the docket, it appears that there was, there's notations of publication. And I do know my client, we became aware that the estate was opened. I can't say what formalities were followed or were not followed, but I can say that my client became aware of the probate action and did file a timely notice of claim in that action relating to the same theory that we're dealing with here.
You say he did?
He did, yes, he did file it within 6 months. And that was the action that we're talking about that's still listed as open in the docket as far as I can see. But
Right. So what I'm wondering is why the personal representative or whoever actually, whichever people were actually involved, appeared to have taken steps to remove the property from the estate.
we would ask the same question, Your Honor.
Okay, well, we'll give you a few minutes in rebuttal, and let us hear from counsel for, well, I guess it's counsel for the estate, right? Or is it counsel for, well, let us hear from Ms. Lockhart.
Good morning, Your Honors. May it please the court. I am counsel for the estate and the personal representative, Ms. Martha Woodland. The trial court did not err in granting the appellants Martha Woodland's and the estate of Ella Mae Woodland's revised motion for summary judgment. The issues before the court are whether the statute of frauds is applicable to the alleged contract between the appellant and the estate of Ella Mae Woodland, well, the decedent, as how I will refer to her, or Ms. Woodland. And if so, whether there has been substantial partial performance sufficient enough to remove the contract as an exception to the statute of frauds.
Well, can I interrupt you on that point? Just as a threshold matter, do you agree that the trial court erred in stating that nobody raised the question of substantial or partial performance? And isn't that itself a reason to send this back?
Your Honor, I do not agree that the trial court did not address that. And I did argue that even at the hearing, the ex parte hearing, the appellant's counsel raised the issue that the payment of $11,307 showed partial performance. And my argument was that it wasn't substantial. When the original claim amount was $320,000, if you take that amount, although appellant never provided evidence of that amount, that payment would only be 3% of the original claimed amount. Even if you take the $187,000, that percentage would not qualify to be substantial partial performance.
But if someone's paying back when they can, I mean, do we expect them to substantially perform if they don't have any more than that? I mean, what he got, as counsel pointed out for you was, or as counsel pointed out for us, excuse me, was literally all of the money that the decedent had at the time from a particular judgment. That's 100% of that amount.
Well, counsel also argued that there were other general loans between the parties during this 2-decade period of time, and that there's no evidence that that repayment was for this alleged loan that they're claiming before the court now. That could have been for another general loan. So there's no evidence to say which loan that payment was in reference to. And
Can you-
so-
I would have thought that the reason substantial partial performance is relevant is if it's enough to show, if it's enough to constitute evidence confirming that the debt existed. And so even if it's a small percentage of the total debt, if the circumstances permit an inference that from this payment of $11,000, that the debt existed as the plaintiff contends, doesn't that resolve the question of whether they've done enough to take it out of the statute of frauds? Assuming it's in the statute of frauds to begin with, which is a separate issue.
I don't believe that it does. And only because the exception says that partial performance may take the case out of the purview of the statute of frauds, not that it's absolute. And I don't think that that portion of a payment, if it was related to this alleged contract or loan contract, was sufficient to do that.
But what do you understand the judge's ruling to be on the partial performance issue? If you say it was litigated, I don't understand what he means when he says neither party alleges substantial partial performance. Do we have a ruling to review?
There's no rulings to review, but in my brief, my motion for summary, that's my motion for summary affirmance, I'm sorry. I would assume that the court is saying that in the revised motion for summary judgment, the parties, the appellees did not argue for the partial performance argument. However, it was discussed at the ex parte hearing. And in reviewing and making a decision on a motion for summary judgment, the court is to consider all evidence before the court. And they are to construe the evidence in light most favorable to the non-moving party, which would have been the appellees before the trial court. The second issue is whether the condition precedent was satisfied, causing the loans to become due and payable. Appellees argue that the condition precedent was not satisfied The testimony of the appellant before the trial court was very clear. There was a condition precedent. The loan was to be repaid at the time the property was refinanced or sold. The property was never refinanced during the decedent's life, and the property still has not been sold.
But isn't there a factual dispute over whether that is what the agreement is? The appellant would say it wasn't until refinance or sale. He would say it was as soon as you can and at the latest refinance or sale.
But that was not the appellate's testimony before the court at the ex parte hearing. His testimony was very clear. It was due at the time of refinance or the sale of the property. And the court must take the evidence as it is and cannot assume what it may have been.
If we posit that there was a contract and that the statute of frauds does not preclude its enforcement, then it seems to me your argument implies that it was improper for the defendants, the appellees here, to remove that property from the estate. They should have, it was an asset of the estate that could have been apparently the only asset of the estate. And the estate had a debt. And if sale of that property was a condition precedent, then didn't they have an obligation to sell it?
I would say in the probate case in the District of Columbia, the Virginia property is not an asset in that case. There would have had to be a foreign estate opened in Virginia, and the property would have been held in that estate, and the appellant would have had to file a claim in the Virginia case versus to get that money from the property.
Is that right? I thought if the court has jurisdiction over the estate,
They have
Then-
jurisdiction over the estate where the
then
property is in the
it doesn't
district.
matter where in terms of ordering the estate and the personal representative to do some things, it doesn't matter where the property is located. The personal representative can be ordered to collect and amass and dispose of the property as is required. I mean, we're assuming personal jurisdiction over the personal representative, which I think is by definition going to be true. But if the estate is open to you, so I'm still sort of hung up. Even if we view it as a condition precedent, that doesn't mean other people can come in and thwart the whole obligation by sort of grabbing the property for themselves, right?
Well, in understanding the court's question, however, because the estate was open in the district and I'm not counsel for the estate.
I
in the
take it the
matter.
decedent died in the district, right?
Correct.
And was a resident of the district.
The district could only have the personal representative dispose of the assets or distribute the assets in the district. They could not dispose of assets in another jurisdiction.
Well, I would have thought the court could order the personal representative to, collect the assets wherever they are and do whatever needs to be done with them, sell them or what have you. The personal you don't have to bring a separate suit, do you, in Virginia against the personal representative to order the personal representative to do that just because the asset is there?
I believe you would, Your Honor. I believe you would. Even in just a correlated case, even in a divorce case, if parties own property in other states, the district court can only adjudicate or dispose of assets in the district.
Well, we're not talking about the district court disposing of the asset, the Superior Court disposing of the asset. We're just talking about the Superior Court ordering the personal representative who's before the court, properly before the court, to amass the assets and to do with them what should be done with them.
Correct, but according to the appellee's claim, that would be requiring the personal representative to possibly do something that they could not do in another state. For instance, if the property had a tax lien or something, they would not be able to dispose of that asset until that lien was satisfied.
That could
even
be
if-
true, that could be true in the District of Columbia too. Well, I don't want to spend a lot of
But
time.
that's also not the case here. Clearly, there weren't liens or anything, and it's actually a little bit concerning that the probate matter can move so slowly here on our end, but somehow they could jump in and I'm not sure where in the record, whether, because that we're not reviewing and we couldn't review the Virginia case itself, but where the publication was and all these other notices that would have gone out and how they just moved this asset so quickly, and how somehow, despite this person not being the personal representative, I guess I'm confused. You're saying this asset is not an asset of the estate, and that the personal representative just had a right to do with it as they please, despite it being owned by the decedent previously?
It's not an asset in the estate in the District of Columbia because it is not property in the District of Columbia. The probate court requires you to list all of the assets that the decedent holds in the District of Columbia. But Your Honors, I will say that given the appellee's argument, I would say that the parties may not have even had a contract. And so the material terms of the contract were not determined, correct? There was no time period. There was no set amount. Those are material terms of a contract. And those things have to be decided, even in an oral contract, for there to actually be contract formation. And while appellees did not brief that issue, that is an issue that the court, I would assume, has to address, is whether there was actually a contract formed in order to even get to the statute of frauds issue. And the appellate counsel argued that Taz, as he calls him,
Did the court make a finding that there was no contract formed?
the court did not make that finding,
So that issue is not before us, right?
correct?
Okay.
But appellate argues that the trial court erred when it said that the loan payments were gifts. In addition to noting that it was not a loan, appellate counsel notes that one of the writings was listed on one of Ms. Woodland's bankruptcy statements. Ms. Woodland filed bankruptcy after the creation of this alleged loan contract, but the appellee was not listed as a debtor in that bankruptcy. In addition, appellee also drafted a will for Ms. Woodland to sign. And in that will, which was exhibit before the trial court, he stated that he wanted the property transferred to him as an inheritance. The drafted will by the appellee never discussed a loan at all. And that's a document that was created by the appellate. So if there was a loan, it did not say that the property was being transferred to him as payment for the loan. It also is irrational that the appellate would loan the decedent more money than what she paid for the property. In 2001, appellee purchased the property for $70,000. To claim now, when the decedent isn't here to argue, which is also really the reason behind the statute of frauds, is to prevent fraudulent claims, to say that he loaned $187,000, which is more than half of the value of the condo at the time that the loan agreement was made, because the appellee testified that at the time that Ms. Woodland purchased the property, that's when the contract was made. At that time, the property was only worth $70,000. So what would be the rationale behind paying more than or loaning more than $70,000 when it was very clear that Ms. Woodland couldn't even afford the $70,000 because appellate was making the payments, as he alleges?
Those sound kind of like factual issues, but you raised the issue of the gift ruling of the trial judge. And do you have, what is your position on the the appellant's contention that the burden, the judge got the burden wrong, and the judge seemed to treat this as a presumption of a gift, when the case law seems to be fairly clear. I haven't seen any case law the other way that you've provided, but fairly clear that whoever's saying it was a gift has the burden to establish that. What's your position on that?
I do not argue that there is a presumption of a gift. What appellee's argument is that the course of dealing and the nature of the relationship between the parties, given that appellee took Ms. Woodland as his paramour and he provided living expenses for her over 40 years, and gifts, and including monetary gifts.
Is that a fact that's in the record?
Yes, the appellee did testify to the fact that he did provide living expenses for her. He did provide gifts. The trial court asked substantial questions in regards to the nature of the relationship and what appellee provided to Ms. Woodland during their relationship. Even after the appellee testified that their relationship ended, he continued to financially support her.
I guess the word paramour was the one I was wondering about, if that was really supported in the record. I understand that he acknowledged a romantic relationship for a period of some, relatively short period of time, given the length of their friendship.
That is not the appellee's position. I think appellee's position was clear in the brief and all pleadings before the court. Appellee began a relationship with Ms. Woodland when she was of the very tender age of 14 years old. And he continually provided for her from that time until the time of her death.
Ms. Lockwood, one last question. What do you make of the various items of documentation that appear to acknowledge the existence of a loan?
I would argue that it presents evidence of a loan, not necessarily this loan that's before the court. Appellee has just argued that there were other general loans throughout the course of the parties' relationship. And the notes, the writings could be identifying or indicating those other general loans, not this loan that was made allegedly in 2001. One of the writings was from 2014. So there's no correlation back to the alleged loan that was made in 2001 when Ms. Woodland purchased the property.
Would other loans be any less due from the estate then?
Well, we don't know what the terms of those loans were. That even with the $11,307.04 that was repaid, that could have been the total amount that was owed on the loan. We don't have any information or facts about the other general loans. So we don't know what the amounts of those loans were, or if those payments.
Well, when you
were
say
in
we
total
don't have,
satisfaction.
when you say we don't have information, we have Mr. This is, I apologize. We have the plaintiff's testimony about it. And I would assume that this is a fact question for a trier of fact. Wouldn't you agree with that?
I would not, only because the only loan that was before the trier of fact was the loan which appellate said was related to providing for the living expenses or the mortgage and the HOA fees that he paid. It was not related to any other general loans.
Well, I mean, my understanding, maybe I have this wrong, was that what appellant was saying was, look, over time, I lent her a lot of money. It wasn't all at once. It was lots of money that I gave her, and she understood it was a loan. And I can't even document all of the $300,000+, but I'm able to document, about $180,000 of it or so. And it was in multiple payments. It was to help her pay her condo fees. It was to help her pay her mortgage. It was for this, it was for that, and it all adds up. And our arrangement was that she understood and agreed that that these were loans and she would pay me back. And she didn't have a lot of money, so she wasn't going to pay me back realistically until the condo property was sold or conceivably refinanced. But it's not a question of, well, which loan are we talking about here? It's a question of the total agreement that they had, and that's, as I understand it, appellant's claim. Now, it's a fact, it may be a fact question, but I don't know that it's susceptible to a legal
Well,
resolution.
the response to that would be appellant had no intention of being repaid. The appellant was very clear that Ms. Woodland was unable to repay the amount that he was dishing out to her. And that there really weren't loans to begin with when you look at the will that was drafted by the appellant. There is no reference to a loan. There's no reference to repayment for the loan or transfer of the property as payment for the loan. It just simply says that the property will be inherited by the appellant. There is no and at that time that will was drafted, appellant knew that Ms. Woodland was sick. He was in the hospital with her, and literally on her deathbed, he presented this will, and she would not sign it. That's why it is an unsigned will, which is in evidence. He didn't just draft a will and keep it in his pocket. He presented it for signature, and it was not signed.
Well, all right, I think we have your argument. Let us hear very briefly from counsel for appellant in rebuttal.
Your Honors, I think it's clear from the appellee's argument that there's a question, at least substantial performance was raised. It's clear in our brief. It's clear in her response that they had made an argument about substantial performance, but we don't have a ruling on that. The judge erroneously said there was no argument about substantial performance. So that's just wrong.
What do you think he was talking about? That it just seems odd.
It does seem odd, Your Honor. There are a lot of things that seem odd about that opinion. I don't know. I can't.
What about what Ms. Lockard said, something about, it wasn't re-raised in some subsequent pleading or something? Is that possible?
I didn't understand what, all our briefs from the beginning in our summary judgment, response to the summary judgment, we said there's substantial performance here, that we made that argument. So I don't know when we would have re-raised it after that, which was our literal last statement in the court below where we explicitly raised it. It was just ignored. Second, to the extent that appellee's counsel argued that there's no indication what loan this $11,307 relates to, it's very clear. The exhibit specifically says there's an exhibit on page 118 of our appendix signing over the $11,307.04, and it says paid back TAS for mortgage loans, LMA Woodland. So that payment related to the mortgage loans. So to the extent there's a question about what was a loan and what wasn't, I think based on that, we should be able to at least infer that my client's arguing that any mortgage payment he made was part of the mortgage loans. And we broke down because we foresaw a possible jury type issue about what these loans were for. So we broke down X amount was specifically for mortgage payments. X amount was specifically for unit owners' fees, because we foresaw that it was possible that a jury might say, well, the mortgage payments were a loan, but everything else wasn't. So we specifically broken down the amount paid directly for the mortgage. And these are monthly direct payments to the mortgage company by my client, basically from very early on in the loan, where he paid every single payment. So when she repaid him for mortgage loans, it clearly relates to the loans to the mortgage payment. I think the record is clear here, Your Honor, that the court's opinion he inadequately made factual determinations that were inappropriate at the summary judgment stage, and he applied the incorrect law. So we'd request that
Before you sign off, sorry, can I ask you one more question? What,
of course.
your argument about basically the judge's ruling on the statute of frauds not extending to other claims besides a breach of contract claim, the like unjust enrichment, are you still pressing that argument, and how is it clear that the judge's ruling did not encompass those claims?
I'm not even sure whether they moved for summary judgment on the other claims, but yet the opinion dismissed the whole case. At the default hearing, which ostensibly should have just literally been over damages, it quickly turned into what's the theory of this case and is a breach of contract supported? And there was no, even though my client testified as to the facts that would support unjust enrichment, there was no ruling on the unjust enrichment claim, period, as far as I can see. And there's also promissory estoppel against just the personal representative, because it's basically against the estate, but the personal representative standing in the stead of that. But for the brothers, the siblings,
Do I
who got
understand that the
property, we have
premise-
unjust enrichment. Yeah.
Do I understand that correctly, that the premise of those other equitable claims is that there was a valid enforceable contract? In the absence of that, there is no unjust enrichment claim that that appellant can bring. And similarly, doesn't sound like there's any promissory estoppel claim that appellant could bring.
Well, we did not have the opportunity to litigate this factually below, and there was no ruling on it. But my understanding is if the court were to find that there wasn't enough specificity, if the term mortgage loans wasn't specific enough and the court found there was no contract, we would still have an equitable claim that based on the decedent's repeated promises to repay and his
I see.
putting himself out there over and over all these years. She was just leading him on. And under that circumstance, it's unjust for the personal representative to then get everything as if the promises had never been made. So it's sort of as an alternative, Your Honor. And unjust enrichment is simply because the two other siblings, all they did was be enriched by this inheritance that we say, if things had been done correctly in DC, they may not have had, because the property may have been sold in order to satisfy the debts. But the brothers who are not Martha Woodland, they weren't making promises. They didn't do anything except receive a share of the property. So we wouldn't have promissory estoppel against them or Martha Woodland individually. It would just be against the estate.
Okay, counsel, we thank you both. And the case is now submitted and you may log off.
Thank you, Your Honor.
Thank you.
We'll call the next case on the calendar, Jefferson 11th Street versus Anna Asensio et al. Counsel, good morning.
Your Honor.
Call the case and Mr. Cornwell, you may proceed.
May it please the court, my name is William Cornwell. I'm here on behalf of Jefferson 11th Street LLC and its members, Ellis J. Parker and his two sons, Stuart and Hill Parker. This case involves a 90-year-old building that was reaching the end of its useful service life when the controversy we're going to be talking about arose. The LLC members sought to complete a hardship petition and a complete rehabilitation of the property in 2012. And the tenants opposed the hardship petition and for the first time made housing code violation claims that thwarted that effort. To skip to where we are and what the appeal is about, there are 4 issues. I'm going to address very briefly 3 of them and spend most of the time on the last one. The first issue is that there was an award of $265,000 in attorney's fees on the statutory indoor mold case claim, the only claim that the plaintiffs achieved a success on. The court awarded $265,000 in attorney's fees, which was excessive. The plaintiffs' actual damages were 0. What they were able to prove at the trial level was $1,250 in expense to have a mold assessment done. They withdrew and waived their claims for breach of contract and damages and injunctive relief because proceeding side by side with this case is a receivership case brought by the district that addressed much of what the tenants initially sought to address. The court's award of fees in this case was disproportionate to the outcome achieved. Much of the time for which fees were awarded was spent on the mooted claims. In addition, time was spent on supporting the receivership petition, which is inappropriate because that petition, which also has resulted in a judgment, which is going to be on appeal before this court shortly and is set for briefing as we speak, resulted in the court awarding an award of attorney's fees in that case. And so by awarding the tenants attorneys fees for their work, including their work supporting the receivership petition, my clients have been subjected to double fee awards, excessive fee awards. In addition, the court erred in considering an unaccepted offer of settlement in considering the award of attorney's fees. And as we set forth in our papers, that's absolutely contrary to the district's case law that says that's the reasonableness of a settlement offer can't be considered in deciding fees in a case. And that's the Beck versus Test Masters Educational Services Inc. case at 73 F Sup 3rd 12. It's a 2014 opinion.
I know you want to get to a later issue, but just on this one, what about the argument that you waived this issue in court and opened the door to the need to use the mediation information to rebut a claim that you all made?
We disagree that there was a waiver. That was what was asserted and adopted by the court below, but we certainly never voluntarily, freely, voluntarily, or otherwise waived the disclosure of those for use in consideration of attorney's fees. In any event, again, the fee award's excessive.
For what use did you agree that the court could consider the settlement?
Frankly, I don't think we ever did agree. I was not there, so I can tell you that the record doesn't reflect that there was a waiver at any point with respect to the consideration post-judgment of attorney's fees. I think that came up in the liability phase. The court bifurcated summary judgment on liability and damages, and I think it was a subject that was discussed in the liability phase.
Can I ask you before you proceed? I also have a question about something else you just said. You argue that to the extent, if I understood you correctly, you argue that to the extent part of the award of attorney's fees related to fees incurred in support of the receivership action, that was not an appropriate component of the award of attorney's fees. May I ask, is that, and forgive me if I'm misremembering, is that an argument that you've made in your brief?
Yes, it is. In both the initial brief and the reply brief.
Okay.
So moving to the next issue, the court erred in awarding treble damages for the indoor assessment mold cost that was done. Those were costs. They're not damages. DC Code Section 8-241.052 specifically provides that the court should award those costs for when a plaintiff succeeds in proving mold. And this was an assessment cost, not damages, and it was error for the court to treble that award. And while it was only $1,250, it was error to conclude that this issue. And again, the court made a waiver, adopted a waiver argument by the plaintiff, and that's wrong because in that case, clearly the waiver, if there was any, was on liability, not on the damages. And they lack standing to even recover these treble, any treble damage award because they failed to provide the indoor mold assessment to my clients as the statute requires within more than 60 days prior to filing suit. And this is a jurisdictional issue that can't be waived. As we argue in our papers, the statute, the mold statute that is, requires my client, the owner of the building, to receive the written mold assessment and to not remediate the indoor mold within 60 days. Well, the record shows the case was filed in November of 2016, and there was no 60-day period prior to filing where this mold assessment was provided to my client to respond to it in accordance with the statute.
Counsel, did your client remediate the mold by January 2017?
No, the mold, and remember that the receivership petition was proceeding side by side with this case, and I'm not exactly sure the date that the receivership petition was filed, but no, I don't believe that the mold was remediated within 60 days of the filing of the action, if that's your question, Your Honor. So moving to the issue I want to spend most of my time that I have remaining on, and that is the court erred in holding Ellis J. Parker liable personally as the alter ego of the LLC. The court found in the receivership case on May 29th, 2018, that Mr. Parker individually was liable to fund the receivership plan. In this case, the tenant mold case, the court found that Mr. Parker was collaterally estopped by that order in the receiver case from denying that he's the alter ego of the LLC. This is wrong for several reasons. The tenants attempt to overcome the problem by saying that the May 29, 18 alter ego order of the court was a final order appointing a receiver that could have been appealed immediately. Well, that's wrong because the receiver order was entered 6 months before that in November of 2017. And Mr. Parker was found to personally be responsible to fund the receivership plan, as I said, 6 months later. So there was no interlocutory appeal of the receivership order that would have reached the issue of alter ego liability of one of the members. The court erred in holding Mr. Parker liable on the issue of alter ego as summary judgment was precluded because there was conflicting evidence on each and every point asserted by the plaintiffs' appellees in their motion. As this court's well aware, the question of whether one is the alter ego of an entity they're a member of is a question of fact. Here, the record established at a minimum disputed issues of fact with respect to each and every assertion the tenants made concerning Mr. Parker's individual exposure to piercing the veil or alter ego.
How was the decision made in the receivership action that Mr. Parker was the alter ego?
May 29th of 2000.
So I know when it was made, and I read it, but what is your understanding of the basis on which it was made? Was there a trial? Was it a summary? Was it a de facto summary judgment ruling?
Yes, the latter.
The latter.
No trial. And the tenants argue that there was opportunities to contest the evidence they submitted that went unrebutted, which is just false. In fact, I'm looking at the dates right now. The court received proposed findings from the plaintiff concerning the individual liability of Mr. Parker February 9th, 2018. Below, the defendants filed a supplemental brief in support of their opposition to that individual liability on February 24th, 2018, and an amended supplement on March 1, 2018, the contents of which I'm going to discuss briefly here in just a moment. Those submissions largely consisted of Mr. Parker, who was 86 at the time this deposition was taken, his sworn testimony in this case. For example, the tenants argued to the court below that the LLC maintained no records. His testimony was absolutely contrary to that assertion. In fact, his testimony was that because he and his sons don't live or reside or work within the district, they employ a management company, a company by the name of SCF Management, to maintain the LLC's records, and that there was copies were provided to him, and they cite the testimony that he gives in his deposition that he did not maintain those copies that were forwarded to him by the manager. To say the LLC maintained no records was utterly false.
Let me just interrupt you for a second. I don't want to stop you from making this argument, but I want to clarify something in my own mind. Is the issue before us whether there was sufficient evidence to support a finding or a summary judgment ruling that Ellis Parker was an alter ego, or is the issue before us solely whether the requirements for collateral estoppel are satisfied?
I think it's
my
both.
question.
Yes, I understand.
In other words, the receivership decision is not directly before us on appeal in this case. If whether it was right or wrong, if it was, it may not be an issue before us if collateral estoppel was properly applied. Whereas on the other hand, now I have some questions about that too, but whereas on the other hand, if collateral estoppel was properly applied, then one might say, well, that's the end of the inquiry, although subject perhaps to some sort of revisiting if in the receivership appeal, the underlying decision is overturned. You see what I'm saying?
I understand.
So
your
I'm wondering
question
whether
entirely. I agree with you that I apologize, Your Honor. I didn't
So I'm
mean
wondering whether before us now is the question of whether the evidence justified by whatever standard we think is appropriate.
I think it is. And I believe that because
ultimate
collateral
determination.
estoppel was improperly applied, we reached that issue before you now, because there's never been an opportunity for my clients to be heard on appeal with respect to the initial finding in the receivership case. It's coming, but it may be coming too late for this case. And so,
Well, you see, I'm thinking, and I really don't want to get ahead of your argument because I do want to hear what you have to say. But I'm thinking that although you may be correct that the alter ego determination in the receivership case was not immediately appealable, that may be correct. Otherwise, the requisites for collateral estoppel treatment were met, and the lack of immediate finality may be excusable, just as it was in I think it's Davis, the Davis case. Although that was a factually different case, I well understand. And there are some reasons to think that, well, it was final enough, as it were, for present purposes. And So if that is true, I could imagine one outcome being, well, okay, the judge did not err in, or we would not find error in the application of collateral estoppel here, but the alter ego determination in the receivership case has become final and is now on appeal. And depending on what happens in that appeal, this decision may or may not stand up. And one aspect of that approach is it avoids this panel evaluating the merits of the underlying alter ego determination, which are really at issue in the receivership appeal. So you see what I'm saying? That's why I'm trying to clarify what really is the issue before us.
I understand your concerns, Your Honor. I get it. There was never any ability to contest these findings in the receiver case because the court ruled that the defense was collaterally estopped by her findings in the receivership case. But that order couldn't be a final order in our view because it was not appealable. There was no right of review. By simply saying a receivership petition.
But it's not like anything happened subsequently to undermine that order, and indeed it is now on appeal.
Right.
So you sort of wonder, maybe I should ask you one other question that's been bothering me. These two cases, the receivership case and the tenant's case, were consolidated. And they were consolidated, the judge at one point said for all purposes, which is probably not quite precisely correct, but they were consolidated for the purposes of discovery and avoiding duplication of effort. And, you know, we don't have to have two hearings when one will do. Why is it that that consolidation doesn't, in effect, make or should we view that consolidation as making the judge's ruling, quote, in the receivership case, unquote, regarding alter ego status, also a ruling in this case, so that in effect, the judge shouldn't have really said, you could say, the judge shouldn't have really said, well, I'm granting collateral estoppel effect to that. What the judge should have said is, look, well, this was a proceeding in this consolidated, in these consolidated matters. We came to a resolution, and that resolution binds the parties in both matters.
I don't disagree
Now,
with
nobody's
you.
made that argument on appeal.
It's troubled me. I wasn't involved in the underlying litigation, but I've had the same procedural question you're raising. I think the court viewed it in the manner you just described. I can't speak obviously for Judge Pan, but her orders seemed to indicate that her adoption of collateral estoppel was, in her view, essentially what you just said. I've already decided this, and these cases are.
It may be one way of looking at this is to say, well, when
Yeah.
she said collateral estoppel, she just meant, I don't know, maybe. All
What
right,
is-
I didn't want to interrupt you, but the procedural aspects of this have been giving me a headache.
I hear you, and I'm right there with you, Your Honor. I think, again, that the court didn't want to replow this ground, and this is why we had to address these issues in this appeal. It is not clear what is the
Maybe we should have
appropriate.
consolidated this appeal with the receivership appeal. It's a little too late for that, right?
Yes, here we are. Going back to the basic core findings that the court relied on in the receiver case to adopt her order of alter ego, piercing the veil. The argument was made that Mr. Parker used the building to benefit himself and his sons to the detriment of the tenants. Mr. Parker testified that and I'm quoting, "We have never received any money from that property. It has been a drain since we took it over." So there's no evidence in the record whatsoever other than argument that Mr. Parker benefited from the building. In fact,
But
the evidence is to the
counsel,
contrary.
wasn't the property used as collateral for other LLCs owned by the same members? to get loans for the benefit of those LLCs?
It was listed as collateral for a loan long ago that was, I believe, by 2013 or 14 paid off and released. It has never been mortgaged. The property is unencumbered, was unencumbered then. It was merely listed, as you just suggested, Your Honor, as collateral for a rehab on another LLC owned by this family. It never encumbered the property.
Let me ask you, what is our stand, if we're getting to the issue of the underlying merits of the alter ego determination, what is our standard of review? Are we reviewing this as we would review a summary judgment ruling, or are we reviewing this as we would review just a determination by the trial judge as trier of fact?
I believe you're viewing it as a summary judgment in a light most favorable to the non-movement, my client. The judge entered a judgment on essentially finding that he was liable for the debts and obligations of the company on summary judgment. The tenants argued below that Mr. Parker identified himself as synonymous with the LLC and testified that the building was his private property. That's utterly and completely false. Mr. Parker, in fact, testified that he and his two sons each own 1/3 interest in the LLC that owns this building, that he personally never owned property in the district, only interests in LLCs that own property in the district.
So to be sure, I understand, it would not be, in your view, enough to sustain the ruling for this court to say, well, a reasonable trier of fact could find, and this church did find, that Ellis Parker was the alter ego of the LLC. To sustain the ruling, we have to find that there's no genuine dispute of material fact about that determination.
I believe it's the latter.
Yeah, okay, I just wanted to be clear on that.
Absolutely. Another argument the tenants raised, Mr. Parker personally caused the LLC to be undercapitalized. There's no record evidence, much less competent, undisputed evidence that Mr. Parker or any other member of the LLC ever took capital out of the LLC after it was initially capitalized with unencumbered property valued at over $2 million. The initial capitalization of this LLC included two properties, as I just mentioned, that there's no dispute, were worth in excess of $2 million. So this argument that the company was undercapitalized really has to do with the insufficiency of the cash flow generated by the rent-controlled building on a 90-year-old building that's reached the end of its useful service life, with tenants who want a new building but don't want to pay more rent. So the legal arguments on these issues are clear. The alleged lack of observing corporate formality is not a valid basis to pierce the veil under the DC LLC statute. I mean, we quote from section 29803.04B, which says, and I quote it, in the commentary, subsection B, this subsection pertains to the equitable doctrine of piercing the veil, conflating an entity and its owners to hold one liable for the obligations of the other. The doctrine of piercing the corporate veil is well established, and courts regularly and sometimes almost reflexively apply that doctrine to limited liability companies. In the corporate realm, disregard of corporate formalities is a key factor in piercing analysis. In the realm of LLCs, that factor is inappropriate because informality of organization and operation is both common and desired. So this not only doesn't support piercing the veil, it actually runs counter to the actual express language of the statute governing LLCs in the district. No single person dominated the LLC. The record evidence established that Mr. Parker, who once served as the managing member of the LLC, seldom, if ever, made any decisions without consulting the other members, his two sons. That's an issue of fact, again, that precludes summary judgment on the issue. This, and I'm quoting his testimony in his deposition. There was no evidence of commingling of LLC funds and assets, none. The members put money in, was his testimony, including money to repair items after, long after they had become owners of the LLC, but never took any money out, period. There was no evidence that the LLC was used to perpetrate a fraud or a wrong. Neither the district or the tenants ever argued that the LLC was formed to perpetrate a fraud or other wrong. Instead, the district argued piercing the veil was appropriate because Mr. Parker is, quote, a wealthy man, close quote, and should bear the risk of financial loss as an injustice would occur otherwise. This is not a basis to pierce the corporate veil. The district argued that Mr. Parker is not entitled to limited liability protection of a corporation when the corporation is insolvent by design. But again, this goes back to the initial capitalization of the LLC, which was over $2 million in unencumbered property, no mortgage, no debt, no loans.
At
So
the time of the litigation in this case, what was the LLC's capitalization?
consisted of, again, unencumbered property, exactly what it had been all,
And to this day, does it have this unencumbered property?
yes.
So if there's a judgment for a few $100,000 or whatever, I don't know what it amounted to, all told, against the corporation, and there was no alter ego to look to, I take it that the assets could be levied on?
Absolutely. Assuming that you are aware, I assume that there's been a bankruptcy filed by Jefferson LLC. So I don't want to mislead.
Right,
the
I was
court.
getting ahead of things perhaps, but right.
In sum, the attorney's award was excessive given and not proportional to the outcome achieved. The court erred in considering this unaccepted settlement offer in making its decision about the award of attorney's fees. In fact, the court was even troubled by awarding fees after the receivership order was entered because essentially the tenant's claims were mooted and yet awarded all of the fees claimed by their attorneys for the time period significant of fees after that receivership order was entered. The court improperly trebled the indoor mold assessment cost as damages when it's not. And finally, what I've argued for most of this argument, the court erred in piercing the corporate veil where there was substantial conflicting evidence precluding summary judgment on that issue.
Okay. We'll give you a few minutes in rebuttal. Let us hear from your opponent.
Thank you.
May it please the court. I'm Daniel Pariser, representing the plaintiffs' FLEs in this case. Your honors, I believe this is the first occasion for this court to hear a case involving the mold statute enacted back in 2014. And the purpose of that statute is clear. It includes a fee shifting provision and treble damages to incentivize landlords to promptly remediate mold instead of engaging in stonewalling through protracted litigation. But in this case, the landlords did exactly what the statute is meant to prevent. As Judge Pan found in a reasoned and thoughtful opinion, and I'm quoting from the opinion, defendants acted in bad faith when they refused to acknowledge or to remediate the mold issues in the building, despite receiving ample notice of the problem over an extended period. Defendants willfully misrepresented the conditions in the building by denying the obvious presence of mold, apparently because defendants sought to avoid their obligations to remediate the mold. And defendants' repeated false denials about the mold infestation were misrepresentations that had severe consequences for plaintiffs who were forced to live in the contaminated units. None of those findings, your honors, are contested in this appeal. Instead, the appellants offer overly technical excuses, which the court should reject. I want to now address their principal legal arguments one by one. I'm going to take my argument a little bit out of order and skip to the alter ego point because that was the subject of much discussion and questioning. So I want to first of all highlight the fact that the challenge to the Superior Court's finding of issue preclusion is a narrow one. The only element that the appellants contest is the element of finality. That element was explained and addressed most substantially by this court in the Davis versus Davis opinion that I believe Judge Glickman referenced from 1995. And in that case, the court abandoned, for purposes of issue preclusion, a strict finality requirement in the sense that the order needed to have gone through the appellate process and been finally resolved on appeal. And instead, what the court found in a case involving a divorce proceeding was that the interlocutory order in that case was subject to collateral estoppel effect, even though the case had been voluntarily dismissed before a final judgment had been entered. And in doing that, the court cited the restatement second of judgment as sort of a leading authority on this area. And in particular, cited the reporter's note to comment G of section 13 and the leading case of Lummis versus Commonwealth, a judge-friendly opinion. And to quote from this opinion, finality in the context here relevant, meaning issue preclusion, may mean little more than that the litigation of a particular issue has reached such a stage that the court sees no really good reason for permitting it to be litigated again. That's the flexible approach that the restatements adopted. I think importantly, for this case, comment G of the restatements also notes as follows. The fact that the parties were fully heard, that the court supported its decision with a reasoned opinion, that the decision was subject to appeal or was in fact reviewed on appeal, are factors supporting the conclusion that the decision is final for purposes of preclusion. And to specifically address Judge Glickman's comment, I do maintain that the ruling concerning the alter ego liability that was part and parcel of the receivership decision in this case was immediately appealable. The statute at issue is DC Code 11-721A2B. And what it provides is that the District of Columbia Court of Appeals has jurisdiction, not just from interlocutory orders appointing receivers, but from orders which take steps to accomplish the purpose thereof. And it is absolutely plain that that language encompasses the ruling of the Superior Court finding Mr. Parker individually liable so that the receivership could be funded and so that the repairs could be made. And if it makes sense, Your Honors, in keeping with the purpose of the statute, why orders like this are immediately appealable. Because in a receivership proceeding, the rights of the parties and their reliance interests are going to be irretrievably altered if one waits till the end of the case to make decisions. A building cannot be unrepaired. The money coming from Mr. Parker's pockets to the contractors to make the repair cannot be realistically clawed back at the end of the case. And that's the entire reason why the interlocutory appeal right exists in this case. At most, Your Honor, it would be a wholly technical appeal to wait until the receivership proceeding was done and then to somehow seek recompense. So under those,
I take it as it turned out, after the ruling on alter ego was made, the receivership was funded.
so it's been part.
And the money came nominally, or you might say, but the money came from the LLC.
Actually, what happened, Your Honor, was the LLC in a hearing, I believe, back in March of 2018, basically told the district court, we don't have the money to fund the repairs. They were looking for $1.8 million. And it was only at that point that the Superior Court said, well, I need to reach the issue of alter ego liability in that case,
Right.
and made her find it. Then that $1.8 million was funded, I believe, Your Honor, by virtue of this alter ego ruling.
Oh, that may be true. That may be true, but my understanding was that it was funded, as I say, nominally perhaps, but by the LLC, which would have made it hard for Mr. Parker to appeal because he wasn't the source of that funding. How do you explain that?
I disagree. I do respectfully disagree, Your Honor, whether or not he actually chose to write the check. And I'm not sure in the record we have a copy of who signed the check. The point is after he was found individually liable, the money came. But since the order was
he wasn't going to be able to get it back if he won on appeal.
Well, I mean, Your Honor,
the LLC gave it to if I'm correct, that it's the LLC that technically gave it to the receivership.
But Your Honor, he knew at that point that he was on the hook for this money. And that was plainly a step taken under the terms of the statute to accomplish the purpose of the statute. So if he wanted to
but what would
protect
the
his
appeal have-
rights,
What would the appeal have accomplished for him?
well, I'll give the court an example. So the receivership continued to proceed. And what happened is that more mold and problems were found to a greater extent than it was expected, and more money was needed. And so the court had to come back and ask for more money. And at that point, Your Honor, the LLC declared bankruptcy, and we're now in a position of great uncertainty. But the point being, if Mr. Parker was on the hook potentially for this money, he absolutely had the right to seek clarity at that point in time to resolve the issue. He didn't even try. And the other point
But let me just pursue something with you, if I may. So the receiver comes, I want to get this straight. The receiver comes back and says, well, we need more money from the LLC. The LLC says, well, we don't have it, and we'll declare bankruptcy. Now, at that point, if I'm the receiver, I suppose I say, well, this is where the alter ego comes in. But did that happen?
I think it did.
Did the receiver go to Mr. Parker and say, you're on the hook now, hand it over?
I think they did, Your Honor. I think that's
They
what
did.
happened
Okay,
when the
that's what I was-
$1.8 million amount was asked.
Well, that's the initial 1.8 million.
Yes.
But I'm talking, which came from the LLC, but as I understand. But you're telling me that later, the receiver had to come back and say, well, we need more than that.
My understanding, Your Honor, and I regret I'm not as familiar with the sort of posture post appeal, but I believe that the proceedings are sort of in stasis right now, given the bankruptcy and all the issues surrounding that, the application of automatic stays and the like.
But why
And
would
there's a
that
motion-
affect, but the automatic stay doesn't, at least to my knowledge, you'll tell me if I'm wrong. The automatic stay doesn't protect the anybody but the LLC from actions. It doesn't protect
I would-
Parker if he has a debt.
I would hope and expect Your Honor is right, but I'm not a bankruptcy practitioner, so I won't venture so far as to say
Neither
that
am I.
that's a certainty.
Yeah.
My point, Your Honor, is the appeal could have been taken at the time, or at least it could have been attempted. And the basic premise, Your Honor, is with respect to issue finality, it's a flexible doctrine that judges have to apply sensibly. And this judge, looking at the circumstances surrounding her orders, concluding on the record that her orders were appealable and no appeal was taken, was justified in reaching a conclusion that there was sufficient finality to give the proceedings issue preclusive effect.
So if we accept that that is true, the consequence of that our cases would seem to further imply is that if in the appeal of the receivership action, the alter ego ruling is overturned, then in this tenants action, Mr. Parker can go back, I presume with a Rule 60B motion, although maybe there's some other route, I don't know, and get relief because the collateral estoppel ruling cannot stand if the ruling on which it is based is overturned on appeal. Do you agree with all that?
I do, Your Honor, and to elaborate, I think this is governed by Section 16 of the Restatement Second of Judgment, which recognizes some of these procedural complexities that the court has observed and essentially gives the court two choices. One is to stay the first appeal
Oh,
until
we could do that too.
second-
Right.
you could do
That's
that.
right.
You could stay the first appeal until a final judgment is reached, or you can affirm, and then in my view, extremely unlikely event, with all respect, that the determination is reversed in the receivership appeal at the end of the day, then the appellants can go and seek recompense. But I think it's very important, Your Honor, to note that I actually disagree with the characterization of counsel for the appellants with regard to the status of the appeal. The notice of the appeal that was recently filed by the appellants relates to the District of Columbia's consumer protection claim and the judgment entered on that claim, I don't see the receivership order included in that notice of appeal. It would not be, in my view, a proper appeal in any event because it doesn't fall within the time period for interlocutory review that we've just been discussing, which I believe is 20 or 30 days, and there's no final judgment. So in my view, that appeal does not affect the receivership proceedings. And if the court were to take the route of waiting and staying the case, who knows when that will be heard? It could be years. And that, I would submit, Your Honors, is not doing justice to the plaintiffs in this case.
Well, in your view, so in your view, do we, in this case, if we think collateral estoppel is satisfied, do we get to the question, or, well, either way, actually, I guess I should say, do we get to the question of reviewing the underlying decision on alter ego status?
So my answer to that, Your Honor, is the court does not need to. It is sufficient to affirm the ruling based on collateral estoppel. However, if the court wishes to draw that conclusion as an alternative holding, it is absolutely justified by the record. And to answer Your Honor's earlier question, I would say,
You know where I'm
maybe
going,
I'm
right?
forecasting
No,
the
you know
question.
where I'm going. Go ahead.
I do. I think I do. With regard to sort of the standard of review, I would say, Your Honor, it would be absolutely appropriate to not apply the summary judgment standard because these matters were consolidated and the law of the case doctrine applies. In other words, putting aside appellate rights, the fact that the court hearing an equitable proceeding in the receivership, making factual findings, reached the conclusions that she did, is conclusive for the tenant's proceeding in that case. Put another way, the district court was not required to hold another summary judgment standard under a different set of principles in terms of the level of deference given to findings and essentially conduct a do-over. But that being said, Your Honor, I'm very confident in this record. Even if the court reviews it under the summary judgment standard, giving the non-movements the benefit of the doubt, the summary judgment standard still provides that in order to create an issue of disputed fact, there must be material facts that the non-movement puts in the record, and they must be sufficient to convince a reasonable juror to find in their favor. And I would say on this record, Your Honor, there are no such facts creating a genuine issue of material disputed fact. What the appellants do is they nibble around the edges. They create quibbles on issues that are not material, and they ignore the critical issues concerning veil piercing that demonstrate that the conclusion really can only go one way on this case. And if I may briefly, Your Honor, address the Lawler factors, which the court frequently uses to make these determinations. Number one, domination by a single shareholder. I think that the appellants mainly rely on the operating agreement here, which says that Mr. Parker only has 33% control. But I think what is dispositive is his deposition testimony. And when he's deposed, number one, he says he doesn't even have a copy of the agreement. That's at Appendix 272. He's asked, have you had binding decision-making authority with respect to the decisions made by Jefferson 11th Street LLC? Answer, yes, I've had the authority to do that. It's the appendix to 273. Then he's asked, Mr. Parker, is one of the purposes of this document, the operating agreement, to establish what your authority is as the managing member or managing member of the company are? Answer, no, I don't think my authority's ever been questioned by the membership. That's at Appendix 272 to 273. Couldn't be clearer than that. What about the adequate capitalization point? I think that's an easy one, Your Honor, because the proof is in the pudding. What has happened in the history of this case? Number one, as I mentioned earlier, the LLC could not fund the repairs. And that is the whole reason that the Superior Court had to find alter ego liability to begin with. And now, Your Honors, we have this bankruptcy filing with the LLC again taking the position that it lacks the ability to fund the repairs. So I think that factor is easily satisfied.
Well, I wonder, why is it that the fact that the LLC was unable to fund the extensive repairs at the current level of tenants' rents and, without a hardship petition and so forth? Really, why does that really mean that there was inadequate capitalization? How do you respond to the argument that, look, this was a 90-year-old building, it was a business, we bought it, we had non-liquid capital that was substantial, and we didn't have the cash flow, but our business plan was we would get a hardship petition, the rents would go up, and we'd be able to fund the necessary modernization. And the fact that the tenants opposed us and denied the opportunity to follow that business plan doesn't mean we were inadequately capitalized. It meant we ran into, bigger problems than we realized. Am I missing the forest for the trees here, or missing the point, or what's your reaction to that?
Well,
But
I think, Your
understand
Honor,
that to be one of the appellant's points.
yeah. Well, first of all, Your Honor, I would just clarify that it wasn't the tenants who stopped them from prevailing on their substantial hardship petition, in the sense they did certainly oppose them, but it was the courts that stopped them because they weren't able to do what they needed to do to make the showing that they needed to make. But Your Honor, I would say that having zero liquidity and relying entirely on the equity of the building, and as a practical matter, being unable to furnish repairs that make the building habitable on a basic level, I think that shows insufficient capitalization for a business that is supposed to be running a building that has tenants. I think the
Well, they would have
ability
been
to
able-
make
Presumably, they intended to borrow the money, from a bank that is looking to the cash flow from, I guess, higher rents, in the future. But all right.
I think that the history proves the point better than anything else, I guess, Your Honor, would be my main argument. With regard to commingling of funds, the record reflects that there was a single bank account for all of the LLCs, which Mr. Parker and his family closely held. And when more money was needed, Mr. Parker just writes a check, including directly to contractors. The fact that he may not have made money on the building is really not the point. The point is he's
Well, wait a
not.
minute, that single bank account, that's very interesting. You're telling me that there's a number of LLCs run by the Parker family, each controlled or owned by the Parker family, but they're separate LLCs with separate buildings and all the rest. And they all share a single bank account?
They share a single bank account held by the property manager, and that's reflected in the District of Columbia's proposed findings at A154 in the appendix.
What's the name on the bank account?
That I don't know, Your Honor, and I'm not sure whether it's in the record. I know it's held by the property manager.
I mean, I ask because, if what we're talking about is simply the profits of the buildings, the profits of the LLCs going to the owners, and, the owners can do with them what they wish. But if it's, that's why I ask what the name on the bank account is. Well, that's an interesting fact that I don't think I was aware of.
And in addition, Your Honor, to address the corporate formalities point, the appellant's counsel relies on a DC statute that addresses corporate formalities not being relevant for veil piercing in the LLC context. But that statute addresses the sorts of formalities that we think about in terms of having board meetings or keeping minutes of board meetings. But if you look at the LLC here, what's not disputed is there's really no corporate existence at all. For instance, no tax returns filed for the last 3 years. That's at A153, finding 40 of the District of Columbia's proposed findings. It had no employees, no office. Most pertinent to these tenants, no policies concerning repairs, responding to complaints from tenants, or how to respond to housing code violations.
Do they owe taxes? They may not have owed taxes. Did
So-
they still have to file tax returns?
My understanding is they would, just like a partnership has to file a Form 1065. They may not have to pay the money, but they need to file a return.
Oh, okay.
At least that's my understanding, Your Honor. I, again, hesitate to give tax advice. And then finally, Your Honor, with regard to use of the corporate form to effectuate fraud, I would emphasize that under the Vuich case, this court has made clear there doesn't need to be actual fraud. There only needs to be unfairness or injustice, and that standard is easily met here. Remember the findings that I stated at the beginning of my argument that were uncontested in this case about the defendant's repeated false denials about mold infestation. And then finally, I think the final piece of the puzzle, which demonstrates use of the corporate form for injustice, is the bankruptcy filing that we've made the court aware of, which is the latest attempt by these landlords to avoid the day of reckoning, as it were.
What's the
So you're-
status of that bankruptcy filing, by the way?
There are motions to dismiss on file by the tenants, joined by the district, also joined by the United States trustee, which is highly unusual as I understand it. And then I believe an opposition is also on file, and no decision has been rendered on the motion to dismiss.
I take it that the filings are not part of the record before us.
We
Those
did,
bank-
Your
those-
Honor,
Those motions to dismiss and
You're not.
we did file a motion to supplement the record, which I believe was accepted for filing, if not granted. And that does have at least the filings by the tenants and by I believe by the US trustee.
oh, it does have those filings, the motion.
I believe it does, Your Honor, yes. So unless the court has any further, I know I'm far over time and I appreciate your indulgence. Unless the court has any further questions, I'm happy to turn to the fee award and address any questions the court has, or I can resume my argument, whatever the court prefers.
Go ahead.
Okay, thank you, Your Honor. With respect to the challenge to the size of the fee award, I'd again emphasize that the challenge here is a very narrow one. The appellants do not challenge their underlying liability or culpability. They do not challenge the court's finding of bad faith. They do not challenge the billing rate that the court approved, and they do not challenge any particular time entry as being unreasonable. And I think that's particularly important, Your Honors, because what we heard, I believe, from counsel for appellants in argument was that there was time spent on mooted claims or on the receivership proceeding that were not properly charged as fees. But the record is very clear that the appellants here did not contest any particular billing entry to say that that entry pertained to a mooted claim or that it pertained to a claim that had been dismissed. That's just not accurate, Your Honor. And I think the most important way to view this case in terms of the fee award is to follow the guidance of this court's decision in the natural motion by Sandra case from 1999. And what the court explained in that case is that in circumstances such as this, a case cannot be viewed as a series of discrete claims. I'm now quoting from the opinion. Instead, the court should focus on the significance of the overall relief obtained by the plaintiff. That's 726 A second at 198. And stepping back, Your Honors, the plaintiffs won this case at every turn. It proved that there was mold infestation. It proved that Mr. Parker was individually liable. We won summary judgment on both of those issues, and then also won summary judgment and treble damages to recover mold assessment costs. And of course, the tenants did win in the biggest picture sense of obtaining an order to remediate the mold. Now, it's true that the tenants did not continue to pursue their injunction claim and that relief was accorded to them through the receivership proceeding. But that should not be held against the tenants. To begin with, these cases were consolidated and the tenants were intimately involved in the district's proceedings, including the plaintiffs testifying at the receivership hearing, including the district using Mr. Spearman, the tenant's mold expert, to testify at the receivership hearing, establishing the existence of mold. That doesn't mean that we're seeking fees incurred in connection with the receivership case. It means that prevailing in that way should not be held against us. To look at it through another lens, Your Honor, if the tenants had continued to litigate the injunction claim after the receivership had been appointed, we would be right here with the appellant's counsel arguing that we generated unnecessary fees, litigating a duplicative and unnecessary claim. The same is true for the contract damages, Your Honor. The contract damages were approximately $10,000, and the tenants decided not to continue to pursue those claims because they wanted to streamline the case, obtain the relief that they had been able to obtain up to that point. And had the tenants continued to litigate that $10,000 claim and generated more attorney's fees, no doubt that appellant's counsel would be making the argument that that was unnecessary and unreasonable to continue litigating those claims. And really, Your Honor, the fact pattern here actually closely mirrors the fact pattern in the natural motion by Sandra case, where the court fully affirmed the fee award. And in that case, what the court observed was, without conceding the merits of his back pay claim, the plaintiff in that case waived his claim for back pay damages to avoid the further delay that would be caused by protracted litigation on this issue. That's at 726 A second at 196. And the decision awarding fees by the Commission on Human Rights was affirmed, with this court stating where a party has obtained excellent results, his attorney should recover a fully compensatory fee. The fee award should not be reduced simply because the party failed to prevail on every contention raised in the lawsuit. That's exactly the case here. Just as in natural motion, the case involved a common core of facts and related legal theories that cannot be separated.
You want to speak to the argument about the judge's consideration of the settlement
Absolutely, Your Honor.
discussion?
To begin with, the court didn't need to reach the issue of what the settlement discussions were in order to sustain the fee award, because stepping back, the purpose of fee statutes like this are to incentivize the defendants to comply with the law. They do not require a plaintiff to abandon a meritorious claim simply because the cost of litigating it exceeds the value of the claim. The whole point is that the defendants bear that risk. So really, the court didn't need to look at the settlement history here. The court bent over backwards, actually, to be more protective of the defendant's rights and asked whether the plaintiffs were justified in continuing to litigate the case after the receivership was appointed. And at that point, Your Honor, the record is absolutely clear, to answer an earlier question, that there was a voluntary waiver. If you look at the appendix at 3114, that's footnote 9 of Judge Pan's very careful opinion. She quotes in that footnote from the transcript, evidencing the voluntary waiver of the mediation privilege. And what that mediation, what those facts showed with regard to the mediation, was that the tenants gave the landlords every chance to cut their losses, offering to settle the case for the attorney's fees expended thus far, or to stipulate to the modest damages of some $13,000 or so and simply litigate the size of the fee award, rather than spending money litigating summary judgment that the appellants were doomed to lose. And the appellants decided they were going to litigate anyway. And again, turning back to the purpose of the statute.
Go ahead. Well, the only reason I started to interject, I apologize for cutting you off. I understood Mr. Cornwell's argument to be that, I mean, I state this correctly now, but I can't both talk and think at the same time. To be that that there was, that although there's a reference to a waiver, there was no waiver. The waiver should not be understood, or could not be understood, as waiving consideration of the settlement discussions for purposes of, for this purpose. Now, maybe I haven't stated the point he made as well as I should, but I think you know what I'm referring to.
Yeah, I think if I understood his argument correctly, Your Honor, he had stated that the waiver was in the context of liability. And I just don't understand that. This was during the course of a specific discussion on summary judgment on fees and damages. And the whole reason Judge Pan brought up the issue was raising the question about whether or not the tenants were justified in continuing litigation after the point that a receiver was appointed. And I mean, Your Honor, again, although she didn't need to do that, this really evidences the scrupulous and meticulous way in which the judge approached this fee issue. She gave the defendants every benefit of the doubt. This was her being skeptical. And after she took the additional facts, she was satisfied. And I would just emphasize, Your Honors, that fee awards like this are reviewed under an abuse of discretion standard. In this case, Judge Pan issued a thoughtful, careful decision. She went back and she did it only after ordering supplemental briefing. She heard a motion to alter or amend the judgment and considered that as well. And this was clearly an appropriate use of her discretion if there ever was one, Your Honors. Unless the court has any further questions, I appreciate the court's indulgence in terms of the extra time. I have nothing further.
Counsel, thank you. Mr. Cornwell, we'll hear you for a few minutes in rebuttal.
Thank you. Thank you, Your Honor. I want to go straight to the bank account issue that you asked about. As you may recall during our argument, and this is in the record and in our papers, the LLC employed a management company. The LLC had no bank account into which it commingled funds collected in rents. It had a management company that maintained sub-accounts for different LLCs employing the management company. So it's disingenuous to suggest that this LLC should be pierced to get to Mr. Parker because the management company employed by the LLC had sub-accounts for more than one LLC that it managed for the owners of this LLC. That there's no citation to any authority to support that notion, and it just doesn't comport with the argument that counsel made. I want to also address Your Honor's discussion about the collateral estoppel. It was error for the court to conclude that the order in the receivership case was collateral estoppel on the finding of piercing the veil. I can't emphasize enough that the order entered on May 29, 2018, piercing the veil, came 6 months after the receivership order that plaintiff's counsel argues was an interlocutory order that could or should have been appealed. There is no basis to appeal the order that was entered in May, piercing the veil under DC Code 11-721. It just isn't. And so
How do you respond to his argument that under the statute as written, this was an order designed to, I should quote the exact words here, which isn't always easy for me. This was an order which was taking a step to accomplish the purposes of the receivership by making sure that the receivership could be funded. So under the statute, why was it not appealable?
It's an interlocutory appeal order that at best is discretionary. There is no mandatory appeal of the order.
Well, that I understand that argument, but I don't hear you agreeing that it could have been appealed. I take it your position is it could not have been appealed, and I want to understand.
It was not an appealable order. We're not aware of anything that shows that it's an appealable order, other than counsel saying it.
Do you agree with the characterization of the order as one that was designed to effectuate the receivership?
No, not really.
I don't know that there's case law that really answers this question. I will.
Yeah, and I agree with Your Honor. I think we've all looked for it, and there is none.
But when you said that your opponent said had no basis for it, he did refer to that statute 11-721 A2B, I think it is.
Well, what I meant, Your Honor, was there's no case law construing it in the manner he's arguing here.
I mean, since no appeal was taken, we'll never know. But
what the plaintiff tenants are suggesting is, with respect to Mr. Parker, anyone who is a managing member of a failing LLC should have if they have wealth, have the LLC pierced to reach them for the debts of the LLC. And that's just not the law. It never has been the law. It's not the law in this district. And their arguments really about Mr. Parker are a house of cards. When you look at the record is clear. There is at a minimum disputed issues of fact. Frankly, I would argue if you look at Mr. Parker's deposition and the actual record evidence, there is no evidence to support piercing the veil here. None. And yet we're told you should ignore that, and you should ignore that there's no precedent allowing the appeal of the order that was entered months after the receivership order was entered, an order that in and of itself could be appealed discretionarily.
This reminds me of something else I wanted to ask you. Mr. Pariser said that the alter ego ruling is not encompassed within the current receivership appeal. Is that correct? I think he, if I understood correctly, and I don't mean to, and I apologize if I didn't, if I understood correctly, the representation is that the current receivership appeal relates to the Consumer Protection Procedures Act claim and issues relating to that claim only. Am I mistaken? Did I misunderstand this?
I don't agree with that. We obviously are appealing the entry of an order piercing the veil in that case, in the underlying case.
I mean, we can
Yeah.
check because we do have the appeal, filed in our court records,
Yeah.
but there's no briefs yet been filed in it.
And the procedure being suggested.
And I guess the receivership, since the receivership is in, excuse me, since the LLC is in bankruptcy, is the receivership case actually open? Is there the possibility of a future appeal in the receivership case, or is that now over with?
I believe there is a possibility of in fact, a likely appeal. In fact, we're here with the court having lifted the stay.
Well, aside from the appeal that's already in existence from the receivership case.
Yeah, I would be speculating.
Yeah.
Just to be very honest with you, I don't know what's going to happen with the existing receivership, the ongoing receivership at the trial court level. But yeah, I don't see any reason why it won't reach.
The
its
receivership is
logical
still going
end.
on, it's still under court supervision and.
Yes. And with respect, going back to briefly the argument about fee and entitlement to fees, the bottom line here, again, regardless of what their basis for arguing it below was, they prevailed on one narrow claim. That is a finding of the existence of indoor mold. And they received and put no evidence of any damage associated with it up, and received a $1,250 statutory award of the cost of mold assessment, which was contested below, by the way. It is illogical to argue what is being argued here, that in and of itself alone would support a $265,000 attorney's fee award, some of which, if not a lot of which, was in duplication of the efforts being undertaken by the district in the receiver case.
Is it
Well,
accurate to say that you don't dispute the bad faith ruling?
In one sense, yes. And I don't want to be intellectually dishonest, but in another sense, no, because as we point out, that is not the trebling of the award for the report was inappropriate because it's not damages. I'm not here to quibble with Judge Pan's finding on that issue, but rather to again, dispute the award of $3,750 on a $1,250 mold assessment cost. They were awarded litigation costs too, on top of the $265,000 in attorney's fees.
Mr. Cornwell, with regard to those, your opposing counsel is asserted that no challenge was made by your party below regarding any of that billing during the consideration of the fees being appointed. Could you clarify your stance there? Like why, if that's the case, is that even something we should be concerned with here at this level?
It was contested. It just wasn't contested on a charge by charge basis. And the record reflects that there was opposition to the fee award and the final judgment on damages in each and every element of it.
Do you think that the comparison You know, if you simply compare the fee award of 200 and whatever it was, $260,000 to the $3,000 in damages awarded, it looks disproportionate. But I wonder if that's really very misleading, because the real comparison ought to be between the benefits of the mold remediation and the cleansing of the building, as it were, to the fee award.
But that was all
And the
accomplished
tenants
in the
didn't bring this
receivership
case, in
action.
other words, just to get a $3,000 award. They brought it in order to get what mold remediation would be accomplished. And on that, they were fought by the LLC. The tenants were advantaged by the fact that the district came in with a receivership. But that doesn't mean the tenants' expenditures were necessarily exorbitant or not to be recouped.
Now, I respectfully disagree that what was obtained in the receivership proceeding. And those awards have been also entered against.
Although, of course,
the
but
LLC.
with the help of.
Those
the-
weren't obtained by the plaintiffs and the tenants in this action. Those were obtained in the receivership proceeding, for which a separate standalone judgment has been entered. But I don't agree that what they affected here was a finding that mold existed at the time they filed their petition. And for that, they were entitled to recover the costs of that assessment and a reasonable attorney's fee commensurate with the result or outcome achieved. No one told them to withdraw or abandon their breach of contract claim, their claim for damages, their injunctive relief claim, nor did anybody advise them, at least from the court, to participate in excessive participation in the receivership case.
Okay. Well, counsel, thank you both very much. The case is now submitted and the two of you may log off.
Thank you, Your Honor.
Thank you, Your Honors.
We'll call the remaining case on the calendar now. Rachel Thorne and Jean Dinga versus District of Columbia. Good morning to you all, and fear not, Mr. Jankowski. We often have glitches in doing this. We live and learn.
Hi,
How are you and Mr. Allen dividing your time?
Your Honor, I'd like to use 10 minutes of our allotted time to address the immunity issue. And of that, I'd like to reserve 2 minutes for rebuttal. Mr. Allen will use the remaining 5 minutes, and he will address the gross negligence issue, if it pleases the court.
That's okay.
Morning, Your Honors. I'm Vincent Jankowski. I represent appellant Jean Dinga. And with me in my virtual counsel table here is Mr. Allen, who represents appellant Rachel Thorne and her children. Your Honors, today we're asking the court to reverse the grant of summary judgment to the district. The trial court erroneously ruled that there were no facts from which a jury could conclude that the district's employee was not responding to an emergency, thereby assigning plaintiff the higher standard of gross negligence. Now, at the outset, I'd like to make a distinction, which cases make, particularly Duggan, makes between an emergency run, which is a legal conclusion, and responding to an emergency, which is a factual matter, which the witnesses can testify to. And where the trial court erred in two respects is, one, it read out of the definition of emergency run the language about for the purpose of dealing with an emergency. Certainly, the district's employee was entitled to go expeditiously to the call that they received, but it was not in response to an emergency. Certainly, a jury could conclude that. The evidence of that is there's a number of facts which are probative of whether or not the officer had a subjective belief, and that's what it is. It's the officer's subjective belief of whether or not he is responding to an emergency. This witness, this officer, repeatedly indicated that he did not consider an emergency. And there's two parts to that test. One is whether the officer had that subjective belief, and secondly, whether it was genuine. In this case, there is ample evidence, almost undisputed evidence, that the officer did not believe he was responding to an emergency. Repeatedly, he was asked whether or not he was responding to an emergency, and repeatedly he said, no, this is a code 2. Code 1 is an emergency. He even said emergency and code 1 go hand in hand. So-
Counsel, let me ask you there. I mean, in Chambers, we found that an officer could testify specifically that they didn't believe it to be an emergency, but the surrounding factors in their actions could lead them to it. The officer in this case kept saying, distinguishing a code 1 between a code 2, but a code 2, and by the way he described it, almost fits the statutory definition here of the emergency run exactly. How should we take it that there's that indicates a belief that it was not an emergency?
Well, the emergency, again, I make the distinction between what is an emergency run, which is the legal conclusion, and whether or not the officer believed he was responding to an emergency, which is the factual matter. When the officer himself, it's his belief, it's not what the definition of code 2 is. It's what he is believing as he is responding to the thing. At least he believes, his testimony, at least the jury could infer, his testimony was that a code 2, he gets a code 2, regardless of what the legal definition of it is. In his mind, it's not an emergency, because in his mind, code 1 is the emergency. It goes hand in hand, as he said.
Why would responding to a possible ongoing burglary not be deemed responding to an emergency?
I think a jury could infer that, but it could, in the facts of this case, jury could conclude otherwise.
Now, how could the officer have not thought that he was responding, that he had to respond expeditiously for the purpose of an emergency, if he's told, we're getting a report, an alarm of an ongoing burglary?
Because he says a lot of times these are false. And it seems
Oh, right. A lot of times it's not a burglary, but some of the time it is a burglary.
so it's
He
like,
doesn't know which.
yeah,
He's not going to know until he gets there.
his actions indicate that he was thinking this is probably one of these occasions where it's false. He doesn't make any actions at all to expedite his motions, his arrival at the scene. He doesn't use excessive speed, doesn't use his lights and sirens. He doesn't seem that he stops at all of which, if he was in a hurry to get there, if he really thought it was an emergency, he would have gone faster. He would have put his lights and sirens on. He might not have made the complete stop at the intersection there. So in his mind, he's thinking, here's another, at least the jury could conclude, that's the standard here. Could a jury conclude that given all those facts, could this witness believe that this is just another one of those false alarms? All right, we'll get there when we get there. And that's it. And I think a reasonable jury could conclude that on the facts of this case. He didn't think, he said it. I didn't think it was an emergency, essentially. And his actions seem to corroborate that.
Counsel, let me pose another question to you there that I struggled with a little bit when I was looking at it. You've said that in the briefing, the District of Columbia is getting rid of the word emergency. And as I look at the statute itself in the specific section, I see the word emergency for the purpose of dealing with a supposed fire or other emergency. And then the next entry is an alleged violation of a statute or regulation. Why is it not enough emergency, like word emergency aside, that the officer believed he was responding to an alleged violation of a statute via burglary?
There was no alleged violation of the statute. There was no allegation that a burglary was in fact taking place. It was just an alarm that went off. And a lot of times they go off because they go off, not because of any crime. It's just the nature of the thing. They go off sometimes. I would agree. I would definitely agree if they said there's a burglary in progress. period. If that's all it was burglary in progress, it would fit the statutory definition. But the fact of an alarm by itself doesn't mean that there's any burglary in progress or then any crime at all. So I think that that language about the statute is.
It's sort of a funny thing, isn't it? The purpose of the alarm is to ensure that the police respond promptly to, because it might be a burglary. Could be, it might be a first degree burglary, who knows? And it's sort of funny in a way to hear the argument being made that, well, all it was an alarm. So the police officer was saying, well, it was only an alarm, and so it wasn't code 1. So I could, so I was not on an emergency run. Seems rather not what we expect of our law enforcement, of our constabulary.
Well, that is what the facts are. And this officer, he may have been jaded. I'm not, police officers get jaded. This is a young officer, but people get jaded after a while. People say, I used to be a volunteer fireman, and sometimes they say we're smelling smoke. Okay, you go out, you check it out, and it's, the guy's chimney needs cleaned or something like that. You don't respond to it. You don't go lights and sirens. You don't go busting through the intersections. You just check it out, and there's another, down the street, this guy, there's a cat in a tree, whatever. It might be, but you get jaded after a while. And again, it's the subjective viewpoint of the officer, because he is the one who's operating the vehicle.
But you wouldn't, drive by later this afternoon, right? There's some sense of urgency.
You get there, you check it out. And if, you get jaded on this. And I think this officer was, he didn't seem like, and he said a number of times, these things go off a lot, and that's the way he didn't see, for whatever reason, he didn't seem like he was that concerned with this being an emergency. And that's what the evidence shows. And that's certainly what a jury could conclude based on the facts of this case.
And is it your view of the case law that is dispositive, his subjective view? Are you getting that from Duggan? And is there any sense, like you mentioned, cat in a tree, if we had an officer who viewed it as an emergency to, flashing lights and sirens to get to the cat in a tree, then is that an emergency run under the statute?
It's a subjective test, and I kind of grappled with this. I think at some extreme, it may be that if the officer really believed that when his sergeant said, go get me a cup of coffee and do it in a hurry, that he thought that was an emergency. And so he went lights and sirens to go to the 7-Eleven to get a cup of coffee. At some point, his even if it was a genuinely held subjective belief, at some point, that subjective belief may be so objectively unreasonable that the decision may be other, the court may rule otherwise. However, that's not this case. This case is, a case where the officer could or could not, reasonably. Well, it's not a reasonable standard. So
Could you clarify something for me? Regardless of whether the officer thinks that a code 2 means an emergency, and I think the language is a supposed emergency, but does that matter if the officer subjectively believes, and in fact correctly believes, that he must respond expeditiously? Why do we care what the officer's assessment of the likely problem is that he's responding to, if the officer understands and believes that his duty is to respond to it expeditiously?
Well, because it's the officer who's actually operating the vehicle. He is the one who's determining whether or not he can violate the traffic law. He is the one who's determining whether or not he can and should alert the other motorists and pedestrians and other people on the scene. He's the one who makes those decisions. So it's his belief that is controlling. That makes sense.
But what's significant is the officer's belief that he has to respond expeditiously, is what I'm thinking. Not the officer's assessment of, well, how important is this?
The officer should always respond expeditiously. Even if it's his sergeant says, go get a cup of coffee, get me a cup of coffee, he's got to respond. This is not a quasi-military organization. There's a chain of command there, and you got to obey it. So if whatever the call is, if it's like, hey, go to the corner, there's some guys hanging out on the corner, just check out and see what they're doing. Okay, they got to go there expeditiously. That's what they're ordered to do. So every response, every police call should be responded to expeditiously. But the statute puts that qualifier on there for the purpose of responding to an emergency. So that's the difference there. It's not just any expeditious movement, because every police officer, he's on duty, he's got to respond, he's told to respond, he's got to respond expeditiously. Whether it's an emergency or not, maybe yes, maybe no. In this case, I think a jury could conclude that he was not responding to an emergency, and therefore the trial court erroneously took the issue away from the jury.
Well, I may be beating a dead horse here, but it strikes me that if the officer in every case has to respond expeditiously, then, if that's the rule, then the simple negligence. It's hard to see why gross negligence should have to be proved in some of those cases, but not in others.
Because in
Liability.
the case where it goes to a true emergency, there are things that the officer does in operating the vehicle which transgress the traffic laws. Traffic laws are there to protect the citizens. And if the police officer is not on an emergency call, that is the weight of the public policy.
It's sort of when it's a true emergency and the officer thinks it's a true emergency, he has to respond more expeditiously. and with less concern about traffic laws.
Not less expeditiously, but I wouldn't say less concern about the traffic law. It's just there are things that he can do, that he's allowed to do without liability attaching to the district.
So the bottom line is, your position is this was not an emergency run triggering all the rules for emergency runs, because the officer subjectively did not perceive himself to be responding to an emergency.
I'm saying that the officer didn't perceive himself to be responding to an emergency, so he did have to, or he is held to the standard of simple negligence.
Right.
So therefore, in this case, he should not have entered 13th Street without yielding the right of way to Mr. Dinga's vehicle. In any event, I did want to reserve 2 minutes for rebuttal.
Can I just ask you one other question? Isn't your argument in some tension with our case law saying when we have a waiver of sovereign immunity, but we have a limitation or an exception to that, we actually construe or interpret that exception broadly? You seem to be asking us for a more narrow interpretation.
Well, a couple of things about it, and I've looked at that, and the waiver and the exception to the waiver they're a little bit incongruous in some ways. The first sentence of 4-412 is that's a waiver. That is clearly a waiver. The district is waiving its immunity to any lawsuit that involves a district vehicle, essentially. So that is a waiver of sovereign immunity. The second part of it, after the proviso, that's not really related to immunity, because the district's already waived its immunity. That is just basically a threshold of evidence. The district says, we're going to waive that. If the officer's on an emergency run, you can still sue us. And immunity, don't forget, immunity now is not just the right not to have a judgment against you. Immunity is the right not to be sued. So you're saying, the district is saying, if the case involves a district vehicle, you can sue us, fine. But if the officer's on an emergency run as so defined, then you have this higher evidentiary standard. Now that seems to me to be not quite immunity. That seems to be something else. That seems to be telling the jury. That seems to be something for the jury, because the juries normally decide gross negligence. The juries don't decide immunity. The juries decide gross negligence. So I appreciate what the case law says about that, but I don't know that it should, that proviso should be necessarily so broadly worded. And in any event, it is no more broadly worded than what the jury thinks is gross negligence. So, and besides, we're not really asking this court to broadly interpret the proviso. We're just asking the court to think that a jury can do what juries always do, and that is decide issues of gross negligence. So it's not really, it just doesn't seem, I appreciate what the cases say. I've read the cases. I know what the cases say. My own particular view is it's different than an immunity. I couldn't find any case law in other, but it doesn't seem like an immunity. It seems like.
Let us hear from Mr. Allen, and you'll have a minute or two in rebuttal. Mr. Allen?
Thank you, Your Honor. I would like to recite the evidence when viewed in the light most favorable to the appellants. And I would submit that it shows that Ms. Dinga was traveling south on 13th Street. She said she never exceeded more than 20 miles an hour due to weather conditions. 13th Street had one travel lane in each direction with a parking lane on either side. She said that a silver car may have passed her traveling in the opposite direction and that she slowed down as it passed. She never left her lane prior to impact, and she didn't see the police car prior to impact. She felt the impact, but she didn't see the vehicle, nor did her passenger, Ms. Thorne. Now, Officer Bennett said that he intended to turn right on 13th Street, that he stopped before entering 13th Street, but that his view was obstructed by a vehicle parked on the corner of 13th Street in the alleyway, and that he could not see further than 2 car lengths as he looked to his right. That he did not activate his lights or siren prior to attempting his turn. And that the Bennett came out of his alleyway quickly. Now, this is supported by both Dinga and Ms. Thorne, who said that neither of them even saw the vehicle prior to impact. And a reasonable juror could infer from that the vehicle came out quickly. It is also supported, I would submit, by Bennett's testimony that the first time he saw the red car was as he was making the turn. And what he saw was that the red car was adjacent to the silver car. The rear of the silver car was halfway along the red car, and that the impact happened almost instantly after that. Now that silver car had just gone past it. So if that's what he sees as he's making his turn, that could indicate to a reasonable juror that he came out quickly. Now, he did say in his deposition that he inched out. However, he said that in response to a leading question. The question was, did you inch out? And his answer was correct. There is no mention of that, of inching out, in the police report that was taken shortly after the accident. And the other police officers in the vehicle don't recall him saying anything like that. In fact, the first time that there's any indication that that's what he was claiming was at his deposition.
Do you think we gain any insight into the event from the body-worn camera footage?
No, I don't. You cannot tell anything from that as to how quickly he comes out or what his position is at the time of the impact. But we do know that according to Ms. Dinger and Ms. Thorne, he comes out into their travel lane. So he's actually, they're just driving along at less than the speed limit, maybe 15 to 20 miles an hour, because she said she slowed down for the silver car to pass. And that they never leave their lane. Both Ms. Dinger and Ms. Thorne said that. So a reasonable jury could infer from that that the police car came into their lane. So
Now,
he
in making this argument, are you making an argument that this evidence supports a finding of gross negligence?
Yes, I am. And I would like to go through some of the factors that were considered in the Tillery case and apply them to this case. The first factor that the court considered there was that the officer in that case, Officer Hamrick, greatly exceeded the speed limit. Well, that clearly doesn't apply in this case. The second factor that was considered in Tillery is that Hamrick needlessly accelerated towards the intersection and failed to clear the intersection before speeding through it. Now, I would submit that that does apply to this case. A jury could find that Officer Bennett failed to ascertain that there was not a vehicle traveling in the opposite direction before attempting to make what he knew would have to be a wide turn onto a narrow street because of the vehicle parked on the corner. And a jury could find that he came out of the alleyway too fast, given the difficulty of making that turn. So that second factor in Tillery, I think, could apply in this case. The third aggravating factor in Tillery was that Officer Hamrick drove with neither his siren nor his lights activated. That factor clearly applies in this case also. By doing so, Bennett, who could only see 2 car lengths down the road and knew he had to make a wide turn onto a narrow street. If he had activated his lights or siren, he could have warned oncoming traffic that where he was and what he was doing. He didn't do that. So we believe that that is an aggravating factor in this case also. Fourthly, in Tillery, Hamrick disregarded the obvious fact that a construction truck blocked his ability to see the other vehicle. That applies in this case. His view was obstructed.
Am I mistaken, which is possible, from memory, in Tillery, didn't the officer say that he saw a car coming?
Yes, he did.
Down the street. And then, of course, the car was blocked by that parked vehicle, construction vehicle or whatever it was. But he actually saw a car coming and nonetheless went out into the intersection the way he did. That's
Yes,
to be a significant factor in Tillery, if I remember correctly, which doesn't seem to be present here.
I think you're correct. The way I read Tillery is that at some point, Officer Hamrick's view was obstructed. But after that, he did in fact see Mr. Tillery and assumed that Tillery would stop and then sped up through the intersection. That's how I recall it. But there certainly was a point at which his view was obstructed, and that certainly applies in this case too. There's really no dispute about the fact that Bennett could not see very far at all down the road as he attempted to make his turn around the vehicle that was parked right on the corner.
Mr. Allen, does it make a difference for you that in Tillery, the cars essentially collided in this manner, whereas in a T-bone type fashion, whereas in this case, you're alleging that the officer turned into oncoming traffic?
I don't believe that makes a significant difference to the analysis. The evidence showed a reasonable juror could find that Bennett goes into Dinger's travel lane and hits her pretty much head on. How that alters the analysis between that sort of situation and a T-bone, I'm not really, in my submission, it doesn't make a difference. Fifthly, in Tillery, the court considered that Officer Hamrick still attempted to speed through the intersection. And I concede that that does not apply in this case. And sixth, in Tillery, the court found that a reasonable jury could find that there was no genuine urgency impelling Officer Hamrick to disregard safety considerations. And I would submit that that is also the case here. Officer Bennett was treating this as a code 2. As a code 2, he was required to obey all traffic regulations, including speeding. And his actions prior to making the turn indicate that he didn't believe there was any genuine urgency impelling him to disregard safety considerations. He proceeded through the alley at 15 miles an hour. He stopped at the junction with 13th Street. It was the turn itself where he in our submission, disregarded safety considerations. But there was no genuine urgency impelling him to make that hazardous turn at that point. It would have only taken maybe, another 30 seconds or so for him to actually do what he claimed he did, and to inch out and to activate his lights and to activate his siren to let people know that he was coming out onto a narrow street and had to make a wide turn. That would have made almost no difference. And so we think that that factor does apply in this case. So basically, of the 6 factors that the court considered in Tillery, 4 of them favor also apply in this case. And is that sufficient aggravation to amount to gross negligence? We would assume, we would argue that it is. One of the definitions I saw of gross negligence was, seemed to suggest if there's a witness standing there, sees the whole accident, would the accident shock that witness? Now, of course, all accidents would shock witnesses to some extent, but, would the shock be such that, I can't believe that happened? I would submit that if there'd been a witness standing on that corner near the alleyway and saw a police car shoot out of an alleyway, go into somebody else's travel lane and hit an oncoming vehicle that was obeying all speed regulations, going well under the speed limit, that would be shocking to a witness. Now, I accept that there's no bad faith here on the part of Officer Bennett. We're not arguing that there is, but you can still find gross negligence where there is no bad faith. When you can show that the actor acted in disregard of a risk so obvious that the actor must be taken to be aware of it, and so great as to make it highly probable that harm would follow. Now, if you come out onto a narrow street with an obstructed view where you can hardly see anything at all, what's coming in the opposite direction, and you shoot out into somebody else's traffic lane and hit them, is that an obvious risk? And is it highly likely that harm is probable from that? We would submit it is.
Okay. Thank you. We'll give you a minute in rebuttal. Mr. Fallon for the government.
Good afternoon, Your Honors, and may it please the court. Ethan Fallon for the district. This court has consistently applied a broad interpretation of emergency run, explaining in Dugan that all the statute requires is a genuine and honestly held belief by the operator that he should proceed expeditiously on a mission or to a location in response to a supposed emergency, not actual, not real emergency, a supposed emergency. And indeed, that belief that a scenario requires an immediate response may not even be reasonable or justifiable, that the inquiry mandated by the statute is simply whether the officer believed genuinely that he should proceed expeditiously on a mission.
So what about, I understand the lack of a reasonableness requirement that you're referring to, but is there a line beyond which it cannot go? As Mr. Jankowski mentioned, the officer is a real cat lover and, hears that there's a cat up in a tree that they're sending the police to. Is that the sort of thing that would, if he has a genuine, what is it, truly held belief, would that qualify?
Your Honor, I think that you still need to have both parts satisfied under the statute. The first, of course, is whether or not the officer had that subjective belief that requires him to move expeditiously to that situation. And the other part, of course, is whether or not that is a supposed emergency. So in the scenario that you describe, I think there could be a question on whether or not, a stuck cat in a tree or something of the sort might not qualify as a supposed emergency, absent any sort of exigent circumstances that would indicate otherwise.
So are you saying that whether there's a supposed emergency is an objective question, not what the officer subjectively thinks, but when we talk about the officer's subjective belief, it only goes to the question whether the officer should be responding expeditiously? Is that what you're saying?
I do think that whether an officer is on an emergency run is a subjective inquiry, although objective evidence can be relevant to subjective beliefs. So here,
Well, in that case, do you agree with Mr. Jankowski that the officer here, that what's relevant here is that the officer did not have a subjective belief that he was responding to an emergency?
no, Your Honor, I disagree with that.
And in what respect do you disagree with that?
Sure, Your Honor. Two things. One, as this court explained in Dugan, how an officer labels his conduct sheds no light on whether their belief and actions fit the statutory definition of an emergency run. Instead, it is the officer's actions that matter. And the operative inquiry here is answered by applying the statutory terms to the officer's conduct as shown by the evidence. And here, Officer Bennett's actions make clear that he was responding to a potential emergency. It was a tripped residential burglary alarm. And I think if we look to Officer Bennett's testimony, that confirms his belief that he was responding to a supposed emergency. He made clear that responding to a potential residential burglary was urgent, that required responding directly to the location. He also explained—
Counsel, can you help me? Because I felt like this when I was reading the brief as well. It sounds like you're flipping the subjective and the objective. And as I read Dugan, the en banc court talked about some of those objective factors, and they said the justification for the belief is the question of negligence itself. So in this scenario, if I borrowed Judge Beckwith's hypothetical, that objective factor of being sent after, getting the cat down from the tree, and there's an accident along the way, objectively, that would apply to the negligence question, but the officer's intent, that subjective belief, is what gives us the emergency run. Can you help me understand? Because it sounds like you're telling us something different now.
Yes, Your Honor. I do think that the officer's subjective belief is important to qualify under the statute, but the other requirement is that he must respond to a supposed emergency. And so in that sort of fact scenario, I think that it could be considered not an emergency, and that is something that a fact finder could potentially find in that situation. And so it's sort of matched up with both the intent of the officer and whether or not that compelled him to move expeditiously to that supposed emergency.
I apologize. I don't think I may not have been listening carefully enough, and so I apologize. I don't think I understand your answer. The officer gets the call. Mrs. O'Leary's cat is up in the tree. She loves that cat. Would you please respond and help her get the cat down? The officer treats this as, I have to respond. This is an emergency. I know Mrs. O'Leary. This is an emergency. And the officer drives expeditiously and to the scene and gets into an accident. Are you saying that, and the officer's completely credible, he believed it was a true emergency. Very important that he get there in time and save the cat. is that an emergency run in your view for purposes of the statute?
Your Honor, I don't think that, Mike, I don't think that would necessarily qualify under the statute
And
because
why
that,
not? The officer has a genuine subjective view that he is responding, that he must respond expeditiously to a supposed emergency.
Your Honor, I think that the first part of the statute is met there if the officer's beliefs are genuine in that it is an emergency and that he proceeded to go to that location expeditiously. However, whether or not a Mrs. O'Leary's cat stuck in a tree constitutes a supposed emergency could be considered not by the fact finder.
Well, suppose the fact finder finds that the officer believed it was an emergency, but the officer's out of his mind. Well, let's not put it quite so. There are cat lovers, I'm sure, watching the video. The jury disagrees that it was an actual or supposed emergency, but credits the fact that the officer subjectively believed it to be an emergency. What should the jury do?
If the jury found that that was not in fact a supposed emergency, then I do not believe the emergency run statute would qualify under those circumstances.
So in that respect, it's an objective test.
Yes, Your Honor, they're both sort of.
So now suppose something is an emergency and the officer gets the call and everybody would agree objectively it's an emergency. But the officer, for whatever reason, does not think it is an emergency and subjectively believes it's not a real emergency, but responds expeditiously, believes he should respond expeditiously because his superiors, insist on that, and gets into an accident. How do you view that? The officer did not have a subjective belief that he was responding to a supposed emergency, but it really was, and objectively he should have had the belief that it was.
Your Honor, I think that if the situation, in the situation that you described, and the officer doesn't believe it's an actual emergency, but he still responds expeditiously because he was required to do so, whether or not that was based on a code 1 or code 2 call or otherwise told by his superiors, and he proceeds expeditiously to that supposed emergency, I do think that that conduct qualifies under the statute. And I want to clarify a little bit here. The language of the statute does include under circumstances, I'm quoting now, under circumstances which lead the operator or such persons or agency to believe that such vehicle should proceed expeditiously. So in the scenario that you described, the agency, being MPD or a superior officer that represents the agency, would believe that that was a supposed emergency that requires the officer to go expeditiously to that location.
So counsel, in this case, you would distinguish this case from Tillery, Dugan, Chambers, and other ones on the fact that this was not something an officer observed and made the decision themselves that this was an emergency, but the actual decision of potential emergency and the officer needing to move expeditiously is the agency in this case, not the individual in the car making a snap judgment.
Your Honor, I think both apply in this case. Officer Bennett's explanations regarding the code 1s and codes 2 sort of during his deposition made clear that he not only was instructed to treat it urgently as an emergency, but that he needed to respond urgently to that situation. And so I think
counsel, what's getting me is it seems like some of the objective pieces of it that you talked about kind of subsume and completely make the subjective piece that the courts ruled on bond kind of irrelevant there. And so let me ask you this, and what you just gave, if he was instructed and if an officer is instructed to go treat something as an emergency and go expeditiously there, but they do not believe it's an emergency and do not treat it as an emergency at all, are they still on an emergency run?
Your Honor, if an officer responds expeditiously to that supposed emergency and those actions follow that belief or what he was instructed to do, I do think it would qualify under the statute.
So the
And
officer would individually need no subjective belief themselves in that scenario.
he would need the subjective belief that he had to respond expeditiously. So whether or not the officer actually believed that it would turn out to be a realized emergency or not is not relevant in that situation. And as this court in Dugan explained, how an officer labels his conduct really sheds no light on whether their belief and actions fit the statutory definition of an emergency run. And
So who in this case, what evidence was there in this case that anybody thought that the call here was an emergency? In other words, Mr. Jankowski is saying a jury could find that the officer, the driver here, did not subjectively believe he was responding to an emergency. Your answer seems to be, well, but there were other people, they were the people who told him to respond, who thought it was an emergency. And a jury would have to find that.
yes, Your Honor, I do think that both the agency and Officer Bennett believe that. If we look to
You disagree with Mr. Jankowski about whether Officer Bennett, in fact, had the subjective belief. You think a jury could find that Officer Bennett had the subjective belief that it was an emergency?
Yes, Your Honor, and his testimony confirms his belief that he was responding to.
But do you believe that a jury could also find that Officer Bennett did not have the subjective belief that it was an emergency? Or subjectively believed it was not an emergency, however you want to phrase it?
No, Your Honor, not based on these facts. The appellants here do not question whether or not, as a factual matter, the officer moved expeditiously to that supposed emergency, which here was a tripped residential burglary alarm. And so that hasn't been contested here.
You would agree that merely moving expeditiously does not necessarily mean that the officer subjectively believed it was an emergency?
Not alone, not by itself, Your Honor, but here we do have his testimony that he believed he was responding to a supposed emergency. And Code 2 calls are deemed emergencies under MPD policies. And so that, of course, must be treated by an officer responding to it expeditiously to whatever supposed emergency exists in a given situation.
Counselor, they're non-emergency. Oh, sorry, Judge Glidden, go ahead.
Let's go ahead. Well, I was just going to say, just to close the loop, suppose we disagree with you on this point and think that a jury could find that Officer Bennett subjectively did not believe he was responding to an emergency. Where do you think that leaves us?
Your Honor, I think then it would have to go back to the fact-finding jury to determine sort of the negligence standard that would apply in that situation. Here, of course, I think we have both the subjective evidence from Officer Bennett stating that he needed to respond urgently to this supposed emergency of a residential burglary alarm, as well as objective evidence, which includes video from 3 different officers sort of describing or depicting the actions that the officer took in response to this tripped residential burglary alarm. And so
my question is then, are there opposing counsel in the briefing makes a point that, if we're to look at it this way, then every single call a police officer is put on is an emergency. Are there non-emergency codes or scenarios here then under the way you're viewing the law where the officer is not heading expeditiously and this gross negligence is a true exception and not just a blanket change in the immunity waiver?
Your Honor, to clarify, there are 3 codes that the MPD uses, codes 1, 2, and 3, that sort of depict the different types of emergency situations that might involve given the scenario. And so I think that these different codes just address how an officer should respond to them, and they can certainly qualify under the statute if they meet the statutory terms, regardless of what code is necessarily, assigned to that given situation here. And one other important thing that I would like to point out that the statute itself also contemplates, as I believe either Judge Glickman or Beckwith mentioned earlier, that it also covers alleged violations of a statute or regulation. And in those situations, that also qualifies as an emergency run, not just an emergency, supposed emergency.
Yeah, no, that's interesting, counsel. I asked that question, and
Excuse me.
Mr. Jankowski had a great response that I'm interested in your response to as well, that an alarm is not an allegation. That if someone had told the officer that there's a burglary that's going on, that would present a much stronger case. How do you respond to that point that counsel raised?
Well, I think that the ultimate veracity behind the residential burglary alarm here or in other situations don't have a bearing on whether or not an officer is responding to a supposed emergency within the meaning of the statute. The statute contemplates potential or supposed emergencies, not just.
But with regard to an allegation of a violation of statute or regulation, specifically not responding to an emergency.
Yes, Your Honor. If the officer genuinely believes that he must respond expeditiously to that violation, I do think that would qualify under the ambit of the statute.
So a burglary alarm being tripped, in your view, constitutes an allegation, or well, I'll call it a per se allegation of a violation of a statute or regulation.
Well, I think here, Your Honor, I think it qualifies as a supposed emergency, regardless of whether or not that ended up being true or not in terms of the burglary alarm itself. And, by analogy, I don't think anyone would seriously argue that an officer responding expeditiously to a bomb threat was not an emergency run, even if most of those threats turn out to be false. But under the statute, it is that potential or supposed emergency that triggers the emergency run. And so I think that this court should reject attempts to read out the supposed part of a supposed emergency.
Does the term emergency, by the way, have a settled definition?
Your Honor, it is not defined in the statute, and to the best of my knowledge, this court hasn't defined it specifically either.
It's interesting. A lot turns, doesn't it, on an undefined term?
It does, Your Honor. And one other point, if you don't mind, I'd like to mention is that this court has rejected the proposition that an officer must take any particular or specific steps to embark on an emergency run. In Abney, for example, this court held that the use of a siren is not dispositive of whether emergency personnel are on an emergency run. And in Henderson, the court explained that an officer's relative prudence when driving a few miles over the speed limit is also not dispositive on the emergency run question. Rather, the reasonableness of an officer's specific driving techniques goes more to the merits of whether the operator was grossly negligent or not. And here, of course, Officer Bennett was obligated to obey traffic laws when responding to that potential residential burglary. Thus, he couldn't legally speed or disobey other traffic regulations on his way to the supposed emergency. And the road conditions that day, as my colleagues on the other side mentioned, weren't ideal given that it had stormed earlier in the day, which also required Officer Bennett to take an alternative route to get to the location of that supposed emergency. And so rather than stopping where a downed tree had blocked the main road or pausing to deal with that potential public safety hazard, he did cut through an alley to proceed directly to the scene, which underscores the perceived need for expedition. And so, when we both look
So I want to be sure I understand the district's position here, and I'm going to ask you to repeat something that you said before for that purpose. If we conclude that a reasonable jury could find that Officer Bennett did not subjectively believe that he was responding to a supposed emergency, then though the jury would have to find that he believed he had to respond expeditiously, we cannot affirm the summary judgment ruling. It has to go back. We must reverse it, and it must go back for a trial.
No, Your Honor, I do think there are two bases for affirming the judgment below. I think it would still be an emergency run because the agency here, the MPD, thought that it was a code 2 situation because of the trip to burglary, residential burglary alarm.
Are all code 2 situations emergencies?
Your Honor, I do think that as a practical matter, code 2 calls would presumptively qualify as emergency runs under the statute for two important reasons. First, the court has consistently applied a broad interpretation of emergency run, explaining in Dugan that all it requires is an honestly held belief by the operator that he should proceed expeditiously on a mission.
What's the definition of code 2?
Code 2, Your Honor, is sort of it's the second level response to an emergency, something not quite as urgent as a.
How does, I mean, if you're, let's say you're at headquarters or wherever it is, and you have to categorize something. What's the standard for categorizing it as code 2?
To the best of my knowledge, Your Honor, there are no sort of hard and fast rules on what always qualifies as a different code. And so I think that depending on the situation and the information given, once that determination is made, that sort of
Who makes that determination?
I'm sorry, Your Honor?
Who makes the determination that it's code 2?
So
as opposed to code 1 or code 3?
When a call comes in, Your Honor, there's both a sort of automation aspect to it, involving computer analysis, and then as well as a human review of it that might alter the ultimate designation. And so it just depends on sort of the information that's received and who reviews it. And so that's sort of
and what is
a case basis.
What does the person do? They throw a dart at the dartboard and wherever it lands is code 1, 2, or 3, or is there a standard here that the officer applies?
So for dispatch, Your Honor, there are sort of these loose guidelines that if you look to General Order 302.01, which we cite in a footnote in our brief that the court is able to judicially notice if you hope to, if you wish to look at this a little bit more in depth. But these different priorities have different sort of designations, and priority one calls require the use of emergency equipment, so lights and sirens, and priority 2 calls do not require the use of emergency equipment, but it still requires expeditious movement to the location of that sort of supposed emergency. And priority 3 calls, for that matter, also involve expeditious movement.
It sounds like you're saying that, it sounds like you're equating the requirement of expeditious response to the existence of an emergency or supposed emergency.
Your Honor, I think it would be, like I mentioned earlier, as practically speaking, it would presumptively qualify as emergency runs for code 2 calls. But of course, that could be dispelled by any number of evidence that a plaintiff can provide or proffer to the court to dispel that notion. For example, if a plaintiff has evidence that the officer did not move expeditiously, that the officer, stopped by to get coffee and donuts before, proceeding on, then I think that is an argument that the officer did not move expeditiously and did not think he needed to that supposed emergency.
Okay. Well, let us, thank you. Let us hear from, briefly from Mr. Jankowski and then Mr. Allen. Do you have anything you would like to add? Mr. Jankowski, you go first.
Yeah, first of all, I hear the government saying that all the codes, I hear the district saying that all the codes require expedition. They just said code 3 requires expedition. So all the codes require expedition. And if expedition is equating with an emergency, then the statute is meaningless. The definition in the statute is meaningless. So all codes require, that's what we've been saying all along. All responses require expedition. Not all of them require response to an emergency. And also, there's nothing in the record before the district court that said anything about what the definition of a code 2, what the definition of a code 3. Next, the government uses the word supposed a fair amount, right? The supposition is on the part of the operator of the vehicle. It doesn't make sense if we're doing a subjective standard. The supposition must be the supposition of the guy who's driving the vehicle. So that really.
Counsel, I actually have a question about that because it was not something I had thought about before, but I'm now struggling with it. In these other cases, Dixon, Chambers, Tillery, Dugan, we've had officers that were deciding based on their observation and a snap judgment that they need to engage in a pursuit, and in some cases in violation of protocol. But in this case, they were directed by dispatch. And this statute section says the movement of a district-owned vehicle by direction of the operator or of some other authorized person or agency under circumstances which lead the operator or such persons or agency to believe that the vehicle, et cetera, and so forth. Is this case distinguishable, and should we be looking at the subjective determination of MPD and dispatch instead of the officer themselves, or looking at it in addition to, as Mr. Fallon contends?
I think the subjective test is important, and it needs to be. It is always important because it is the operator of the vehicle who's making the subjective calls as to how to operate the vehicle, whether or not he should exceed the traffic laws in these kinds of things. Now, the language about the agency, I mean, there's no evidence here that the agency determined that code 2 was per se an emergency. So I don't think that argument gets the district anywhere. The operator of the vehicle, at least he interpreted it as saying this is not an emergency, given his experience and whatever.
Counsel, just to be clear, what you were saying here as well is that even if this was on the agency and MPD and dispatch, that the factual record is not sufficient below, and so that would also be a question of fact. Is that what you're implying?
Yeah, yes, that's one of the things I'm implying, yes. The other thing, Judge Glickman asked a question about how significant is the term emergency. And it is. And there is no definition of emergency. But those are the kinds of things that lay people sitting on a jury can determine for themselves. Whether or not this officer believed he was responding to an emergency. And of course, if you use the subjective standard, I guess you maybe don't even have to get there. Because if the officer says, I'm not responding to an emergency, that pretty much should end the inquiry right there. If you're talking about a subjective test. So one other thing I'd like to just to clarify in Duggan, because there's a distinction made in Duggan, on page 664 of the opinion. That is crucial, I think. And Duggan, the officer in Duggan said two things. He said, number one, I don't think I'm on an emergency run. And he said, number two, I think I was responding to an emergency. This court in Duggan said the former was a legal conclusion. It didn't matter what the officer, how he made that legal characterization. It didn't matter at all. But what was important was the officer said, I believed I was on an emergency run. Now here, where this case is distinguishable from every other case, in every other case, we don't have an officer who's saying, I don't think it's an emergency run. This is unique, and I think it would essentially destroy the subjective test in Duggan if this court was to hold, well, the officer, he had this subjective intent, but it is outweighed by these other factors, these objective factors. The objective factors really go in to show the genuineness of the officer's reasonably held belief, which in this case, it corroborates his not his reasonably held, but his genuinely held belief. And the facts in this case corroborate it because he is proceeding just like he's going to a cat in a tree. He doesn't respond in any different way than he would respond to a cat in a tree. So I believe that's all I have, unless your honors have any other questions. I will yield the table to Mr. Allen.
Thank you. Mr. Allen?
Well, I don't believe counsel of the district actually talked about gross negligence, so I don't think I have anything to rebut. I'm happy to respond to any additional questions in the court, however, if the court has any additional questions.
Okay, I don't hear any. So counsel, well, thank you for your arguments. The case is submitted and you may log off.
This honorable court is now adjourned.